in the matter of Phones for You Limited and EE Limited and others.
Yeah. Yes.
My lords, my lady, I'm going to continue my submissions on ground 3.
Yeah.
And I'm going to now move to the cases of Almadeni and Satyam.
Yeah.
If we look at Almadeni at authorities tab 9, please. As the courts heard, the issue in Almadeni was how did an industrial accident happen? A real paper fallen to the claimant. The claimant pleaded that it had been put there by a Mr Brack, another employee. That was the factual basis of the claim of negligence and as to causation. And if we look at page 521, one can see the particulars of negligence. And 6.8, if we just scroll down, specifically pleads that Yoginder Brack failed to secure the roll of paper. And as the court heard, the judge decided the reel was put there by another employee, and this became known as the third man theory. And Mr McLean did show you this case, but I just want to show you what we take from the case. So if we could look at paragraph 21, please. Sorry, I haven't got the page reference. 526. And if I can just make the points. Paragraph 21 says that in an adversarial system, it's for the parties to identify the issues and the judge adjudicates on those issues alone. Paragraph 22 says that the starting point is the pleadings and that the pleadings identify the issues and the extent of the dispute. I'll take it quickly if I may, because you have read this, I think. In paragraph 23, it says that the claimant had pleaded that Mr Brack placed the wheel on the machine, and if she wanted to advance a different case, she needed to plead that case by an amendment, and having not pleaded the point, she couldn't take it in closing. Paragraph 24 says that because the possibility that someone else placed the wheel on the machine wasn't in play, it wasn't explored in the course of the trial. And the conclusion is at 25. It says the claim, you'll see in the third line, the claim was not proved, and we've seen the claim in the particulars earlier on. And it goes on to say towards the bottom of 527, by making findings for which the claimant was not contending, it seems to me that the judge crossed the line which separates the adversarial and inquisitorial systems. So in Almadeni, the alleged wrong as pleaded was based on the actions of a specific person, and the claimant failed to prove that case, and the Court of Appeal decided that the claimant couldn't succeed on the basis of an unpleaded case because the scope of the trial had been defined by the pleadings, and the pleadings excluded the third man theory. So that's Almadeni. And for the reasons I've given, there's no parallel with this case. The pleadings made clear that Phones for You needed to prove not only that EE had information or an expectation, but that the information or expectation came from Vodafone. That was obviously intrinsic to the allegation, and the possibility that the information might have been transmitted in another way was both within the scope of the pleadings and wouldn't have required any amendment, so that the judge's findings were squarely within the scope of the pleaded issues. The second of the two cases in which the Court of Appeal overturned the first instance judge for deciding the case on an unpleaded basis is Satyam, which is tab 25, and this is Almadeni in reverse. This concerns an unpleaded defence, but the analysis is the same. And if I can just explain the fact pattern to you, if you haven't yet looked at it. Paragraph 2 explains that the appellant Satyam was formerly a company called JVB5, or referred to as JVB5, and the allegation was that the company director, Mr Burton, transferred properties away from JVB at an undervalue. And if the court looks at, so that's explained in paragraph 2 on 1228. So one sees the facts as I've just described them. And then paragraph 3 explains the issue, and it says that the judge dismissed the claim primarily on the grounds that the properties were both before and after the transfer held on trust for Mr Sharma, and therefore all that had been transferred was a bare legal title that had caused JVB no loss. The main ground on which JVB appeals is finding that the property held on trust was the judge's own idea, which had formed no part of either party's case. And just to put that in context, if the court looks at paragraph 12.1, just over the page, I think. scroll down, there we are. So one can see in paragraph 12.1, in the second line, at the time, Mr. Burton held the entire issued shareholding of JVB on trust for Mr. Sharma. So the company was held on trust, but not the property. And if one then looks at, go down to paragraph 19, please. This says it can be seen that the essential issues which required resolution at trial were as follows. And the first issue is what were the terms of the transfer, and in particular what was the price. And secondly, was the transfer at an undervalue. So those were the issues at trial. And if we then move to the reasoning of Lord Justice Nugent at paragraph 33. Sorry, keep scrolling. I think it's 2 pages on.
Sorry, which paragraph?
33.
33, yeah, okay.
And really, it's very similar to Almadeni. Lord Justice Nugent starts with the pleadings and sets out what the pleading issues were, and he says that the trial had proceeded on the basis that JVB 5 was the beneficial owner of the properties, and that hadn't been in dispute. So there's no issue that JVB owned the house. There's no suggestion of any trust of the properties. On to the next page, please, paragraph 36. Lord Justice Nugent says that the present case is not one of a party seeking to depart from his pleaded case. So the case had been run on the basis of the pleadings, but one where the parties had addressed in their evidence and submissions in cases that had been pleaded. And then the judgment goes on to set out the same principles as were applied in Almadeni. And then finally, 38, just over the page. If one picks it up in the middle of the paragraph, judges may sometimes think, and may sometimes even be right, that their own theory better fits the facts of that of either party. But if it is wholly outside the scope of the pleaded issues, that is nothing to the point. So as I say, that is the converse of Almadeni. This is an unpleaded defence rather than an unpleaded claim. And so Phones for You has picked up the phrase new theory from these cases, but these are cases in which the court gave the parties the benefit of an unpleaded claim or an unpleaded defence. That's the significance of the judge having created a new theory. These are not cases about inferences drawn from documents, as in this case. And what happened here was the judge decided, after an exhaustive review of the evidence, that he wasn't satisfied that the August email reflected information obtained from Vodafone, and that was a pleaded issue. So if we could then look at Mr Maclean's skeleton, just to make good the point I made yesterday.
Just before you go on, you haven't taken us to Ali and Dint, where...
No, Mr Pickford deals about his skeleton. He's going
right,
to do
okay, thank you.
Yeah, so, core bundle, tab 3, paragraph 46. I'm sorry, do I mean now doing on page 46? Yes, paragraph 85. This says that the case is exactly the same as Almadeni. The parties came to court to dispute whether EE had obtained information about what Vodafone was going to do. They didn't come to dispute whether if EE had obtained such information, it might have come from a completely different source. But I've shown you the pleadings. I mean, the parties did come to court to dispute that. Both EE did in its pleading, but certainly we did, because we weren't privy to EE's internal emails. But what we could say was this information didn't come from us. So we did come to court to dispute whether the information might have come from another source. So my submission that the premise really for this whole ground is wrong. And that brings me to my final topic, which is why ground 3 breaks down when one considers it in the context of the case and the evidence as a whole. As I submitted yesterday, the August email is said to represent the fruits of collusion much earlier in 2014. And the question of whether Vodafone and EE's parents engaged in collusion during that period was the subject of an exhaustive trial. I mentioned the 27 witnesses that were cross-examined about that, and usually for competition cases there was standard disclosure, and not only that, there was expanded disclosure from the personal email accounts and devices of witnesses picked by Phones for You. No stone was unturned, and the upshot of that process was that Phones for You failed to identify or elicit any evidence of any collusive exchange during the relevant period. And as the courts heard, the case that there was collusion in that period was put centrally on the basis of the communications between Mr Hum of Vodafone and Mr Sheen of Orange, and in his submissions Mr McLean continued to link this ground 3 to the case in relation to Mr Hum and Mr Sheen, and one also sees that in paragraph 71 and 72 of his skeleton. And the judge heard Mr Hum and Mr Sheen cross-examined about their communications, and he rejected the suggestion that Mr Hum had provided information about Vodafone's plans to Mr Sheen. We had a trial about that very issue, and Phones for You failed to make out its case. That point is on appeal, and Mr Dimitri is going to deal with it later.
But aren't you compartmentalising now?
I'm not compartmentalising, my lord, because I'm going
But you're saying we had a trial of that issue, and that was decided against Phones for You. And you're making that a point in relation to the irrelevance of this point, but surely the two have to be put together.
They do have to be put together, and in my submission...
So what's the point?
Well, I'm going to come on to what the judge found about those exchanges and why the judge's findings are incompatible with the inference which Phones for You sought to draw from this. And in my submission, the judge did decide the case in the round. He decided on the one hand that there was no collusive exchange during that period, including between Mr Hum and Mr Sheen, for reasons which are incompatible with the inference which Phones for You seeks to draw from this email. Conversely, he decided that this email appeared to represent information obtained in August. So there's no compartmentalisation. He's made findings about the email, about what the email appears to be, and he's made findings about the April exchanges and what might or might not have been learned in those exchanges. So the judge decided the issues in the way that he decided them, but the case is coherent in the round, and the findings are consistent in the round. And when I show you what the judge found about that earlier period, you'll see why the judge reached conclusions which are completely inconsistent and just don't permit the inference which Phones for You wants to draw. So there's no compartmentalisation. It's simply a matter of seeing the reasoning in the round. But the point, the immediate point I'm making is that Phones for You's case on this email was inferential, and whether the email supported the inference that Phones for You wanted to draw from it had to be considered in the context of the evidence in the round. The way ground 3 is put, it's put as though one focuses on bits of the pleading, and the court was driven to certain conclusions on the basis of the way the pleadings would work. I'm in fact making the same point as you, my lord, which is that of course the case needs to be considered in the round, and the judge's appraisal of the direct evidence between Mr Hum and Mr Sheen was obviously not constrained by what had been pleaded about this email. It was one piece of evidence, and the judge's findings are now, as I'll show the court, inconsistent with the inference which Phones for You sought to draw from it. I'm not going to go into all the detail of Hum and Sheen, because Mr Dimitri is going to deal with that under a separate ground. But I do want to deal with one or 2 points. The first point is paragraph 576 of the judgment at 423. Now, one of the reasons the judge rejected Phones for You's case about this is that maybe the court should just read the first part of 576. I don't think you've seen this yet. You could probably stop at the end of the second line of the second main paragraph in a minute. in fact, I'm sorry, it probably is worth reading the paragraph. So might I continue, Miles? So this is the in the round point, my lord. The judge looked at the evidence, and one of the reasons he rejected this part of the case is that neither Vodafone nor EE had settled on their strategies at the time of the discussions, as a point Mr Pickford mentioned yesterday. So in an unchallenged finding of fact, the judge found that at the beginning of April, Mr Hum was in no position to tell Mr Sheen what Vodafone would do because it hadn't made a decision. I mean, it hadn't even decided on its strategy, let alone was Mr Hum able to gaze into the future and predict the time at which Vodafone would execute a plan it hadn't even decided on yet. This is simply not information that was available at the time of the discussion. So given that, Phones for You's attempt to link the email to the Hum and Sheen exchanges, they've always been pretty incoherent, if I may say so, and Mr McLean has strung together the argument that I said yesterday represented false logic, but the argument doesn't even really make sense at a basic level. The email can't be evidence that Vodafone provided the information contained in the email in April if the information didn't exist at the time the exchange took place. This is an inferential case, and the inference which Phones for You seeks to draw, says it seeks to draw, simply doesn't work. So that's an illustration of why we say that this whole argument under ground 3, that the judge was boxed in by one line in the pleadings, leads to absurdity. We positively submit that the evidence needs to be understood in the round, and that's what the judge did. Now, leaving aside these specific communications, Phones for You based its case on snippets in EE internal documents, which were said to provide evidence of collusion. We saw that in the pleading yesterday, and this way of putting the case was addressed at length in the judgment, from paragraphs 426 to 550, and the judge found that none of the material was indicative of collusion. And I'll just give you one illustration, because it's a point made in Phones for You skeleton. If we could look at core 342, please. Page 42. If we scroll down to paragraph 72, it says in the last bit of that, by the 7th of May, after the Sheen Hum communications, Messrs Milsom and Allaire were positing a different scenario, that EE and Vodafone would leave Phones for You simultaneously, and that Phones for You, lacking the time to replace their volumes, would starve. And I picked this point up because Phones for You picked up the point in its skeleton. That phrase features in a note of an EE meeting on 7th of May. That meeting was dealt with in detail in the judgment. Paragraph 578. We could look at 423, please. So that this is a discussion. This is a detailed consideration of that meeting. And if we scroll down to 587 and 425, this deals specifically with this use of the word starve. And the judge says, I think this is stating the obvious. It doesn't suggest that Mr Milsom knew that such a move by Vodafone was likely. So the judge analysed every strand of Phones for You's case of collusion in April and early May and rejected it. And not only did he do that, he accepted my client's case that the contemporaneous evidence was inconsistent with there being collusion at the time the decisions were made. This is the last man standing point I referred to yesterday. The judge makes his findings on this at 408 to 411 of the judgment, and if we could pick that up at 377, please. Now, I can't show the court all of this. It's a reasonably lengthy passage, but it's a really critical passage, and I would ask the court to look at it. One can see the issue in 408, where it says Phones for You submitted this newfound confidence that Phones for You would not survive, showed that Vodafone had been privy to an exchange of information with EE about their respective intentions. And 409, the judge says there is no hint in any of the contemporary Vodafone documents that Vodafone had any such information about EE, and much that is inconsistent with it. And one gets a flavour from 409A and B. Now, of course, this is information flowing from EE to Vodafone. The case is that this was a reciprocal exchange. And I'll go on to show you the judge's conclusion about this in 411 when we get there. And one gets a flavour of it from A and B. One can see that these are internal documents giving consideration to what EE's moves might be, which reflect uncertainty about what those moves might be. And we see Vodafone formulating a defensive strategy to try and mitigate EE's possible moves. And if we then go on, you can look at the first part of paragraph 410, which gives a bit more colour. This concern EE might include an exclusive agreement with Carphone, leaving Vodafone as the last man standing, was emphasised by all the executives in Vodafone UK, and they thought it was important to gain the first mover advantage. This is Vodafone trying to steal a march on EE. It's not coordinating with it. And the key conclusion is in 411. I find this inconsistent with, or perhaps the court should just read that, it's a very important paragraph. So all of this is the antithesis of Phones for Use case, the judge finds, and completely incompatible with the idea that there has been collusion going in both directions. So this is why we embrace my Lord Justice Phillips's point that the evidence needs to be considered in the round, and that's precisely what the judge has done. And the judge's findings about this take us up to June 2014, well past the point at which the collusion needed to have occurred on Phones for Use case to support the sharp change in EE's thinking. And I'll just give you one more reference in this vein at 416. This is in a section dealing with Mr Hum, and it's quite a lengthy paragraph, but I'll tell you what we take from it. The first part of the paragraph says there's a basic credibility issue about Phones for Use whole case here, because it's a case that Mr Hum swapped information with Mr Sheen, but then he kept the information to himself for months while everyone around him ran around panicking about what EE might do, seeking to mitigate EE's competitive strategies. This is basic credibility with the theory of the case. And then the paragraph goes on to identify evidence where Vodafone is seeking to specifically mitigate the risk that EE stays with Phones for Use. So this again would be the total opposite of what Vodafone would be doing if it had inside information. And these are all points which Phones for Use case simply can't answer, and their response is to ignore it. They've just never dealt with it. They've never had any answer to it at all. So coming back to ground 3, Phones for Use says the judge had no choice but to draw an inference of collusion from the email, even in the face of evidence which was incompatible with that inference, and which was specifically pleaded as incompatible with that inference. We say it's not a tenable submission, and it doesn't help Phones for Use to retreat to the secondary case that the evidence might need to be considered in the round, because that's what the judge has done. He has considered the evidence in the round. So in my submission, it's perfectly clear that the Carphone's warehouse theory, as it's been called, wasn't determinative of the judge's rejection of the case of collusion prior to August. The judge rejected that case on the basis of a trial of Phones for Use case and an exhaustive consideration of the evidence. The email was one small strand of the case, and in my respectful submission, it was an exceptionally weak one, given that it came months after the event, and on its face, it looks like it relates to new information, and that's what the judge found. So that's the context in which the judge found this information was provided in August. And of course, I need to stress this point, Phones for Use had no interest at all in proving that this information might have been provided by Vodafone in August, on the basis that it was provided in August, because that wouldn't help its case. But the case just wasn't litigated in that way, and Phones for Use didn't seek to explore that. All of its fire was directed at proving that this sort of information was the fruits of much earlier collusion, and that case failed on the merits. I've given the court a flavour of some of the key reasons why it failed on the merits, and I've identified points which are very clearly incompatible with the inference which Phones for Use sought to draw, indeed which are reflected in unchallenged findings of fact. So Phones for Use's ability to prove that case wasn't undermined by the judge's conclusion that this information came much later on, and on that basis it could have come from Carphone Warehouse. And I said at the outset, once it's recognised that the judge found and was entitled to find that this email contained information obtained as late as August, the point ceases to matter. That's the point the judge made in the permission judgment, because it's common ground then that the information was too late. And that's why I said at the beginning, this ground of appeal fizzles out. Towards the end of Mr McLean's submissions, there was discussion with the bench about whether an error in relation to the approach to this email would create the need for all of the evidence in the case to be reassessed in the round. And you have my submission that there was no error. But even if there were, we say that the impact of any error is entirely contained by the judge's finding that the information came too late, and there's no proper basis for challenging that finding. Any error would be immaterial in the context of the case as a whole, and nothing would be gained by a retrial. So those are my submissions on ground 3, and Mr Pickford is now going to...
Thank you very much.
Can I ask you, though, are you going to say anything about what the defendant's approach was to whether it could have been car phone warehouse? And my understanding was that point was not advanced, or was not put to any witness, and was not advanced by the defendants in argument. Why would that be?
So this is an EE document, and this part of the case is going to be dealt with by Mr Pickford. So I've presented the arguments from Vodafone's point of view. It's not our document, mind you. So
Why does that matter? It's suggested that you provided the information. If you're going to advance arguments, why? I mean, the question is that there's the finding, and then there's the evidence and the arguments. So if your case is it didn't come from us, you might think that the evidential position would be that you would advance evidence or arguments that it didn't come from you. Why didn't you suggest that it came from car phone warehouse? That's what I don't understand.
well, that's a point, my lord, about EE's dealings at the time.
Well, it's also about your dealings. It said that it came from you.
Yeah, but there was no evidence. So taking it in stages, my lord, the case that it had come from us was put on the basis of the exchanges earlier in the year, and I've dealt with that. There was no evidence that it had come from us in August. It's true to say that we didn't advance a thesis as to where the information might have come from, but in our submission, the position was it was Phones for You's burden to discharge and to satisfy the court that the information came from us, and they couldn't do that.
There were very limited sources of the information. I mean, the obvious source of the information as to what Vodafone is expected to do is Vodafone. That's the primary expectation you would have. So if you're going to discharge, if you're going to say, well, actually, no, it didn't come from us, presumably you would be expected, if you had any evidence or arguments to the contrary, you would advance them. You don't have to. You could say, based on all the other matters you've referred to, you don't need to. And I think that's ultimately your position. But the question I'm asking is, the strange thing about this is that the judge has reached a theory. He doesn't find it was the case, but he's reached a theory which wasn't, as I understand it, advanced by the defendants at all. And that's just that's the peculiarity of it. And I'm just wondering if you have an explanation as to why. It would be very simple for you to have said it didn't come from Vodafone, but there are other sources it could have come from. For example, it might have come from car phone warehouse. But you didn't.
Well, I think it's fair to say. I mean, hindsight is 2020, not my lord. But the way that the issue was litigated was, as I've said, this information came from Vodafone during these earlier exchanges, and we said it didn't. And so there were really two sides of the debate. Is this evidence of a collusive exchange in the relevant part of the year, even though this email comes much later? And on the face of it relates to information obtained at that time. And we were really focused on the case that was being directed against us. This was evidence of a communication much earlier in the year. The direct answer to your point, my lord. Yeah. So the point Mr. Hoskins makes to me, and it's a point the court will, I think, hear about later on. Not from me. No, but there was evidence in the case generally about information flowing to the MNO. Yeah. So there is an example which the court will hear, I think, later on, of how the MNOs received information about dealings with the indirects from the indirects themselves as part of those parallel dealings. We didn't make the direct submission that this could have come from car phone warehouse. As I say, we were focused on dealing with the primary case. This was the result of a collusive exchange earlier in the year. And the question as to how this might have happened if the information was transmitted much later, the focus wasn't on that, because that wasn't what Phones for You was trying to prove. And once the judge concluded that the email was the fruits of a later exchange, the issue took on a different complexion.
It's odd because the judge obviously thought it was necessary in his reasoning to postulate an alternative possibility, which he thought was more probable than it came from Vodafone. So he plainly thought it was a point that and it's such a sufficiently important point that he needed to work it out for himself, even though nobody had submitted it. That's the slight oddity about it.
Yeah, and the oddity arises in part because, of course, it was EE's position based on the evidence of its witnesses that didn't have the information. So that's obviously coloured the way that the issue has been litigated as well. I think that's. I mean, you're right to say, my lord, that we didn't advance the explanation. But the point we make is that the judge had to apply the legal principles set out in 84 to 86.
No, and the difficulty with all this, which is really following on, if the judge had raised this issue with the parties, as it seems to me he should have done, then the parties would have had an opportunity to either to seek to adduce evidence from Car Phone Warehouse or not, or at least to make submissions about it. And it may be, for all we know, that Car Phone Warehouse would have had an absolute sort of slam-dunk case, that the information didn't come from them. And they were the subject, and there was a deal between your clients and Car Phone Warehouse that was on the table in May, I think. But it was confidential. So leaving aside the timing point, I mean, I follow what you say about August versus April straight May, I follow that point. But assuming for the moment that it was information that came in at an earlier point in the year, at that stage, Car Phone Warehouse would have been breaching its own obligations of confidentiality under the proposed agreement with your client, and they might very well have a complete answer. We just don't know. I mean, if that had been the case, then the judge would have been faced with the difficulty. Well, if it didn't come from Car Phone Warehouse, it really must have come from Vodafone.
Well,
unless I suppose, I mean, could be market tittle tattle. I mean, I don't know.
But yes, the point I mean that's right, my lord. I mean, there weren't only two possible sources of information, but I do say that the judge has. Well, first of all, he was right to apply the principles in 84 to 86. He had to be satisfied there was no other plausible interpretation. He obviously considered the question of whether this was the result of a collusory exchange in the round, precisely as Lord Justice Phillips put it. I mean, if one gets to your point, my lord, which is that the judge ought to have raised the point with the parties, one still comes back to the last point I made, which is that once the judge has concluded it's an August exchange, which, as I've said, is what it appears to be on its face, rather than one which goes back 4 months, then the point ceases to matter. So if the court were to conclude there were an error, that's why I made the point last of all, we say that it's an immaterial error, because it's common ground that the information was too late. And Phones for You accepts that directly in paragraphs 87 and 88 of its skeleton argument. So that's the bottom line.
Although they said their cases, it must have come earlier.
Well, yes, but I mean, but that's why I've developed the submission in the way that I have.
No, I understand.
But they said that they had a trial of that question. The judge heard all that evidence. He reached conclusions as to whether there'd been an earlier exchange of information. Yeah. He concluded this was late information, and in my submission, that's why the point fizzles out. Yeah. Okay. So I'll hand over to Mr. Pickford if
Thank you.
My lords, my lady, in Mr. Williams's submissions, which I greatly adopt, he has very helpfully covered much of what we had in our skeleton, which means I hope I can be relatively brief. I've got a few points which are intended to be complementary, essentially, to the points that Mr. Williams has been making. First, can I just go straight to grappling with the question from my Lord Justice Phillips? Our case at trial was that we did not have the expectation, the reference in the email is to an expectation from Vodafone. What we said is that we believed, based on what our witnesses had told us, that the expectation was inferred from evidence that was publicly available in the market. So there were a number of pieces of information that we pointed to, like there was an FT article about the MNO's plans in indirect distribution, which is suggesting that they were going to be pulling back. And we also pointed to the fact that Phones for You had revealed to the market itself that its 2 contracts were going to end in 2014 and 2015.
Sorry, Phones for You had revealed.
Phones for You, I beg your pardon, I may have misspoken.
Yeah.
Phones for You revealed to the market that its 2 core contracts were going to end in 2014 and 2015. And I'm just going to give you the reference for our submissions, but I'm not going to take you through all of them because I've got a lot to cover. But the reference is it's Supplementary Volume 2, Tab 29, 616 to 619. But I'm going to summarise for you the sorts of things that we were saying. And we sought to persuade the court that because we knew that we were September 2015, it wasn't very difficult to work out that Vodafone must be 2014. And therefore, our position was that, well, there was quite a lot of bits of information beginning to percolate in the market, and we put them together, and that was our expectation. So that was what we said about it, and that was based also on the fact that when we asked Mr Milson about it, he said, you know, I don't know, don't remember anything about it, certainly didn't speak to Carphone Warehouse.
But the position was that Mr Wilson actually said, did he, that he didn't speak to Carphone Warehouse?
So didn't speak to Vodafone, I beg your pardon.
Didn't speak to Vodafone. I mean, and this is all, the point about the information coming from the market, I understand, but as I understand it, I mean, Mrs Derbyshire, whom the judge accepted was an honest witness, couldn't recall where the information had come from. Didn't remember the email, but I think the general consensus it probably came from either Mr Milson or Mr Alera. Mr Milson, the judge finds, was very defensive about all this, but basically denied that he was the source of the information. So I'm not sure what Mr Alera's position was, but they weren't saying, well, yes, we did pass this information to Mrs Derbyshire, but it was market information available in the market, because they were denying having been the source of the information.
They were denying having been the source of any information from Vodafone, yes, because they said we didn't speak to Vodafone.
They were saying that they weren't the people who passed on anything to Mrs Derbyshire either.
Well, I think Mr Milson just didn't deny, said that he couldn't remember having done so, he didn't remember anything about it. So what we did in the light of their evidence is seek to infer, well, where did this information come from? It might actually be helpful, if I may, to just go back to the email. I'd like to make a submission on the email itself. So it's found in Supplementary Volume 4, page 1329.
Yeah.
So the point that I'm going to make is that I say that the significance of this email is now overblown by Phones for You, because what we say is it doesn't, not only does it not support their case, it in fact undermines their case. So as Mr Williams has explained very clearly, the Phones for You case that we were meeting was that there had been collusion between EE and Vodafone, where they had exchanged their plans, because their case was a mutual exchange of plans back in April. So that by April, EE would have known that Vodafone was going to be legal. That was their case. And so what we see here is an email which says, if Phones for You fold earlier than expected, i.e. in the next couple of months...
Hang on, we need to go down.
I beg your pardon. Sorry, yeah, so it's at the bottom of the page. Sorry, I've got it.
Yeah.
Neil wants us to get this debt completed but the focus is on phones for you. He wants us to be 100% sure of the impact if phones for you fold earlier than expected, i.e. in the next couple of months. The expectation is that Vodafone are about to pull out. Now, we led evidence, and I'm going to come back to some of this when we deal with the modelling section under Ground 4, which clearly showed that EE's modelling at this time was based on the assumption that Vodafone would be staying in phones for you. That was our modelling assumption, that Vodafone are going to stay in phones for you after EE leave, and so phones for you were likely to survive for up to 9 months after EE left. And EE was planning to leave at the end of its contract in September 2015. So what that meant is that our modelling was predicated on phones for you staying alive until 2016. And I'll show you that later on today, assuming we get to it today. So, and that's very clear on the face of those documents. So, so this email is inconsistent with and undermines a case that we knew about Vodafone's plans back in April. It's because the information is plainly new, and it's undermining our expectation that in fact Phones for You is going to survive until 2016. We're at this point in time we're in 2040. So that's to put this point in context. We say this supports our case, not the claimant's case, and that's in my submission helpful for in considering the questions of prejudice and unfairness, and whether this was such a big issue in the case as they now claim. So if I could then go back to the main submissions that I was going to make. Against that background, what we say is that the legal error here in this ground is that Phones for You have conflated the required approach of the court to the facts that must be pleaded and adjudicated on to uphold or defeat a claim. That's what the case law is about. And they've conflated that with the required approach to appraising the evidence said to support or undermine those pleaded facts. That's our case in a nutshell on the legal error in Phones for You's case. And what we say, and I'll develop this further, is that the authorities make clear that the judge cannot decide a case on the basis that would have necessitated the parties having pleaded different facts in issue. And by that I mean the core facts that are necessary to either establish or defeat a claim. But we say it is equally clear that there is no bar on a judge when evaluating the probative value of one specific piece of evidence amongst thousands of pieces of evidence that he considers, to do so taking account of his own view of the inherent probability of what one party is asking him to infer about that evidence. Now, in relation to the law, I'm going to start with a very basic proposition, but it is important, which is statements of case must plead only material facts, meaning those necessary for the purpose of formulating a cause of action or defence, and not background facts or evidence. I am quoting there from Mr Justice Leggett, as he then was in the Chenguiz and Grant Thornton case. I don't think I need to take the court to it. It's a very obvious and fundamental principle. So, first point is that Phones for You shouldn't in fact have been pleading to the 10th of August email at all. I'm not criticising him for that. But what I do say is the fact that they did choose to plead to it doesn't transform it into being anything other than just one piece of evidence amongst thousands in the case. So that's my first point. Now, when dealing with Phones for Use case on that email, the judge referred to the case of Shagang Shipping, and it's probably helpful for the court to see that case. It's in the Authorities Bundle, volume 18, at page 4165. And he quoted in particular paragraphs including 98 and 99. And if I could ask the court please to read paragraphs 98 and 99 of that case.
This is the torture allegation case.
Yes, exactly.
Okay.
I mean, you may be able to do it relatively speedily. That I have a fairly basic point to make in relation to it.
Yeah. No, I'm sort of broadly familiar with the case. Yeah.
So the point that I make, and this case is a very helpful illustration of it, is that whether the information in the email came from Carphone was not a fact in issue, in the sense of a fact that had to be either proved or rebutted for Phones for You to make out its claim or for EE to resist the claim. And so the judge didn't need to make any specific finding on it as such at all. So that was the starting point for the judge's assessment of the email. Now, Phones for You has referred to 3 Court of Appeal authorities. Mr. Williams addressed you on Al-Madini and Satcham.
Yeah.
In both of those cases, what happened is that the judge decided the case on the basis of different facts in issue from those that the parties had themselves pleaded. That was the basic problem. And we entirely accept that if a judge does that, he or she has gone astray. That is impermissible. Ali and Dink illustrates the other side of the line. So if we could go to that authority, please. It's in volume 6 of the Authorities Bundle at page 1354. So you were taken to this by Mr. McLean, and he showed you paragraph 25 in particular in the judgment of Lord Justice Burst, and that refers to essentially the point about considering prejudice. And I'm going to
paragraph.
I beg your pardon. That's page.
Paragraph 25.
Paragraph 25. It's page 1360.
Gotcha.
So he took you to that, and he said that the modern approach places emphasis on prejudice. This is right at the end of that paragraph. And the modern approach, the definition of the issues, requires the judges to adopt a pragmatic approach in line with the overriding objective, and not to seek to be governed by unnecessary formality, provided always that it's just not to do so. So that's the essential approach. And then in relation to that particular case, what the judge went on to say, if one sees paragraph 30, is having analysed what the judge's factual findings were in that case, says, in other words, the judge's conclusions are composed entirely of the acceptance or rejection of factual assertions which were pleaded. Although the re-amended particulars of Claimant didn't spell out the point the arrangement was not a gift and binding honour only, that was necessarily implicit in Mr. Ali's case, and therefore he says it's a long way from Al-Madini or Satcham. And then at 32, he goes on to explain in the third sentence, it hardly needs to be said that the fact that a witness genuinely and unshakably believes that what he did was enter into a sale agreement for a price of 1.35 million and does not countenance any alternative, does not mean that the only logical possibility for a judge is to accept all that wholesale or reject it all. Mr. Ali's testimony was not the whole of the evidence before the judge, and as I say, the findings were all open on the evidence taken as a whole. And then 34, Third, nevertheless, standing back, it's fair to note that the judge's conclusion does amount to a particular intermediate combination of the various factual assertions making up both parties' cases. And the combination itself is one that neither party had expressly pleaded. However, that is commonplace in civil litigation. So, what one, I say, draws from that is that there is, as long as one is within the scope of the factual pleaded
Well,
issues.
if you read the rest of 34,
Yes.
he's making the point there that the I think I'm right in saying the case that the judge had found was fully ventilated in closing submissions.
Yes.
So they'd had an opportunity to deal with it. There's no question of being ambushed, and what will be said against you? Nobody had an opportunity to deal with this case. This information came from Carphane Warehouse, because nobody pleaded it. Nobody ran that case at trial, and the judge didn't say at any stage, well, hang on a moment, what about if the information came from Carphane Warehouse?
Yes. So I
We don't know, because as I said earlier, we just don't know what Carphane Warehouse's approach would have been if they'd been asked. So I'm not sure that this, I mean, I understand why we're having this case cited to us, but I don't think it necessarily helps you in the way in which you say it does.
Well, I entirely accept, my lord, that there, the court will need to consider the prejudice issue, and I am going to come to it. If I may, I'd like to come to it in a few moments after developing a few other points. But I entirely understand it's an issue and it needs to be grappled with, and I'm going to grapple with it. But my point really is this: that where one is in the domain of the judge deciding a case on the basis of facts that fall outside those that have been pleaded, then there is a hard-edged problem and a rule against that. We're not in that territory. We're in the territory of where the judge decided that he was not going to make the inference that had been asked to make by the claimants. And as part of his reasoning for that, not the only reason, but as part of his reasoning for that, he gave a reason that hadn't been canvassed with the parties in the trial. And what I say about that is that in those circumstances, there is no hard-edged rule. It's a matter of discretion as to what is appropriate in all the circumstances, considering the prejudice not only potentially to one party not having had an opportunity to make submissions at that point, but also the prejudice to the parties in restarting an incredibly expensive trial. So that's the point that's what I draw from this. We're not in the hard-edged category. We're in a softer area where there is discretion for the judge. Now, if I could go, please, to the judgment and just show you very briefly some early paragraphs in the judgment that are not challenged by my learned friend, which set out the judge's general approach to drawing inferences and dealing with the factual findings. So that's back in the core judgment bundle, and I'm going to go to page 272. I'm going to go to 272, starting at paragraph 44.
Yeah, yes.
Exactly. So he cites Guessman and Mr Justice Leggett, as he then was, and he says in the top of the second quote in that paragraph, best approach for a judge to adopt in a trial commercial case, place little, if any, reliance on the witness's recollections, and to base factual findings on inferences drawn from the documentary evidence and known or probable facts. And then he goes on in paragraph 46 to quote Lord Justice Robert Gough, as he then was, and again he refers to the need to take account of matters including in the, I think it's the fourth line, the overall probabilities. And then in paragraph 47, he says that he's going to look at the documents and the inherent plausibility or otherwise of the evidence. And then in 48, he explains that there, as regards the contemporary documents, the written communications between people within each corporate group were made by email or text message. Some of those are very short and elusive. I think that it's not in the least surprising. No doubt their meaning was clear to the individuals at the time, but read now, they are open to very different interpretations. I found that the witnesses cross-examined about such exchanges, which they sent or received so many years ago, and which they did not specifically remember, often struggled to explain what they meant. It seemed clear to me that their explanations were frequently speculative and coloured by the case that they wished to support. In many cases, I considered that the obscurity of the text means that it does not provide a reliable basis for any inferences to be drawn. So what he was saying there, and it's a perfectly, in my submission, unobjectionable point, is that there will be some documents that he couldn't actually draw any inferences from because they were not sufficiently clear and didn't therefore help one side sufficiently or the other. So that was his general approach. And then, as Mr. Williams has explained, when it came to this particular email, he adopted an intermediate combination of EE's case and Phones for Use case. Indeed, he essentially adopted Vodafone's case in full, which their case was simply, we didn't give information to EE, and he accepted that. But in relation to our case, he rejected that we had got the information. We inferred that it must have come from a combination of market information and what Phones for You had revealed about its plans. He didn't accept that, but nor did he accept the view espoused by Phones for You that it had come from Vodafone. And what I say is, in the circumstances, and adopting the pragmatic approach that was urged on the courts by Lord Justice Burns, was what the judge did unreasonable? And my answer to that is, of course, no. Because the exercise that's called on by Phones for You involves the judge doing this. They say, well, we asked you to draw an inference from certain evidence. Their case, in fact, in closing, we don't need to see it, but they said, this particular piece of evidence is inexplicable. And obviously, the inference, what I mean by inexplicable is inexplicable other than as showing that we're right about our case. And we say that a judge, when he's being asked to draw an inference about a particular piece of evidence, is entitled to have regard to his view of the inherent probabilities and to use his common sense. And that doesn't mean, in every case, that he has to recommence the trial to put it back to the parties. In my submission, that depends on how important the issue is, and it needs to be seen in the context of all of the evidence that the judge will have had to decide that issue. So if there was a situation where there was obviously one single critical piece of evidence, one single document, that was what a case turned on, and let's suppose that the judge came out with something totally left field in relation to that, that no one could ever predict it. Now, I would accept that even though we're just dealing with evidence, you might say, well, that was outside the bounds of reasonableness for the judge to have proceeded in that way, erred in the exercise of discretion, and therefore that was an error. But in my submission, this falls well within the bounds of what was reasonable, because he had to weigh up, as I said, the competing considerations, or whether it was really sensible to restart the trial in relation to his views on this issue when he came to it. And as Mr. Williams showed you, the car phone warehouse theory is not the only point in play here. There were A, large numbers of other documents, B, even in relation to his analysis of this particular email, he refers to the fact that he simply thought it was inherently improbable that Vodafone would have wanted to give away its plans because of the last man standing problem. So those are my core submissions, and I'm now going to make 3 further points, including on prejudice.
Yeah, okay.
So the first one is a point that my Lord, the Chancellor, made, I think on the first day, which is, in truth, this complaint is that the judge went too far, because he could have just stopped saying that he rejected as unlikely that Vodafone would have disclosed his future plans to his rival, and therefore we didn't accept the inference that was that had been sought to that Phones for You had sought to draw. And I believe
but
that
just reject Phones for You.
Exactly.
Phones for You's case that the information came from Vodafone.
Exactly. Just
so
reject that.
No
case.
idea where it did come from, but I don't accept it came from Vodafone. Full stop.
Exactly, and we say that would have been unobjectionable, and indeed, I think that was put to Mr. McLean, and he didn't demur from that. He didn't say no. That
how it would have been objectionable because it's a piece of evidence. The judge, it's up to the judge whether he accepts it or rejects it.
Quite. So what we say is the problem basically here is that the judge was arguably too conscientious in trying to explain further points of reasoning which helped support his view.
Yeah.
And in the context of a type of complaint of this sort, which is a fairness complaint, it's a due process complaint, we say that that can't transform the process from having been fair into unfair. So that's our first point. Second point is prejudice. Now, I've already explained that my position is that this is not a hard-edged issue in the Al-Madini sense. This is one where there are competing factors that the judge has got to weigh up. So it's about the reasonableness of the exercise of his discretion. And in relation to Phones for You's complaints, that they would have run their case very differently if only they'd known that the judge wasn't going to accept the inference they sought to draw. We say that that is not, in fact, credible on inspection, and I'm going to show you why. It would have been obvious to Phones for You, who sought to draw the inferences from this email, because they were the people who said, look at this email, this is critical, you've got to draw an inference from it. That if the inference that they wanted the judge to draw was that it came from Vodafone, direct, it would have been very useful to them, as part of that case, to discount other means by which EE might have obtained that information.
Well, that's a two-edged sword.
Yeah.
Sorry?
It's a two-edged sword.
It is a two-edged sword, but in my submission, it's a two-edged sword for whoever wants to rely on it. And this was part of their positive case to say, look, this is the email which we say is critical.
Well, their case was it could only have come from Vodafone.
Yes, I accept that.
They were looking to argue it came from somebody else. Because their case was it came from Vodafone. Nobody else was suggesting. Vodafone was denying it. You were saying it's a market. It's insofar as it came from anywhere, it came from sort of market rumour.
Yes.
And to which they were saying, well, that's not good enough. It must have come from Vodafone. Nobody was suggesting it came from anybody else.
Yes.
Some third party who, on the face of it, I mean, one does ask oneself the question: why would Carwork Phone Warehouse want to effectively breach their own obligations of confidentiality? Were they trying to poison the well with Phones for You? We don't know, do we?
Well,
because it was never explored.
so I was.
And I follow your point, Mr. Pickford. Fully follow your point, and I'm sure we all do. That this is a relatively small part of the overall case, but the problem is that, as I think we pointed out during the course of Mr. McLean's submissions, once you start unravelling one or two of these points, then there's a sense in which they tend to sort of go together.
Well,
in terms of the assessment of whether there was collusion overall.
So,
which is really what I mean, that's obviously what, insofar as we've got an overall picture we have to have.
Yes.
On the appeal, it has to really be that. Is this a case in which the court should send it back for a retrial because we think that the judge hasn't dealt with appropriately.
Yes.
The collusion case, and that's in broad terms.
So that's very helpful. My lord, you're entirely correct that part of our case is that this was not the big issue that it's being made out to be. Indeed, we say, actually, you look at this, supports our case, not ultimately, not theirs. But I'm making a different point here, in fact, or a further point, which is, and to respond to the comment from Lord Justice Phillips, our case was the alternative explanation. There is an alternative explanation. The alternative explanation is effectively market info, including what Phones for You themselves have revealed about their contracts and FT, etc. That was our case. So we were seeking to explain it because that was consistent with what we've been told by our witnesses that they hadn't.
But you, who are extremely motivated to provide another explanation, do not suggest car phone warehouse. That's the point.
No, well, we didn't, because that's not what we...
Yet the judge found that effectively, because he said that's more plausible than Vodafone. He effectively found that's what happened.
Yes.
But rejected the market.
Even though you didn't think it was even sufficiently arguable to raise it.
Well,
that's what's remarkable about this.
Well, I'm not sure...
Not just you, but nobody did. Neither did Vodafone. Nobody suggested it was car phone warehouses. And the judge has given a detailed analysis to come to the conclusion that it was.
Yeah, but your point, presumably, is that EE's case on the facts was in accordance with what witnesses said.
Exactly.
So it wouldn't have been consistent with that case to point to alternatives. I think you may be saying that it's more in the... I think you're going to say it's more in the interests of Phones for You to rule out other theories.
That is exactly what...
Well, that's the point that troubles me, because I don't think it's a question... Because, I mean, my lord's absolutely right. Nobody did raise this. But because nobody raised it, and there are all sorts of reasons why there might not have been in your interests or in Vodafone's interests to raise it, but because the judge decided this on the basis that nobody had raised, fairness required that he notify you before he made that finding, so that whoever wanted to make submissions about it or call evidence about it could do so. And the difficulty that we have is that if that's right, it's very difficult to say, well, you can just... I mean, I follow the point about timing. And leaving that to one side, it's very difficult to say, well, if the judge had done that, then it wouldn't have made a blind bit of difference.
Well, I mean, I do make that submission.
I know you do, but I find that very difficult.
But I do also make the submission, this submission, and I stand by it, which is that Phones for You were very, very well aware of the possibility that the information came from Carphone, because they sent a letter before action to Carphone Warehouse saying, we think that you have been engaged in a hub and spoke, collusive practice with Vodafone and EE, and you passed Vodafone's information to EE or vice versa.
But it wasn't in the specific context of this email, was it?
I cannot say whether it's in the specific context of this email, I can't recall, but they sent a detailed letter for action to Carphone.
Carphone denied that. Carphone responded through their solicitors and denied all that.
They denied all of that.
And no claim was ever pursued.
Exactly, that's right. But
they obviously didn't think there was an arguable case against Carphone.
Well, they
sued everybody else.
They, for whatever reason, they decided not to pursue that case. We don't know why they didn't pursue it, but they didn't pursue it. But they were obviously very well aware of the fact that this route might exist because they made the accusation themselves. And so what I say is what they were asking the judge to accept, because it was an inference that they were asking the judge to make, is that this email could only have come, the information that is implicit in this email could only have come direct from Vodafone to EE. And what I say is if they wanted the judge to accept that, they well knew that it would have helped them to discount alternatives, because because that would make their case all the stronger. They can say, look, we think this comes from EE. Why? Why can it only have come from EE? Well, it can't have come from anywhere else. It can't have come from public information, and it can't have come from from Carphone.
So did you submit to the judge at the end of the case that Phones for You could have discounted Carphone Warehouse?
No.
It didn't. No. You didn't.
No.
So how can you argue that now?
Well, what this goes to is the question of how prejudiced have Phones for You really been. I say what they did. They well knew there was a potential route, and they took a risk that when they asked the judge to make inferences that there was no other route other than the direct one, they were taking a risk.
Did they take the risk that when not one of the defendants had suggested that it came from Carphone Warehouse at any stage, and were making other suggestions as to its source, the judge might at the end of the day found it came from Carphone Warehouse? I don't think they did take that.
No.
Well, I'm going to make one more point on prejudice, and then I'm going to move.
Well, I mean, the point.
It's a different one.
I mean, the point we got from Ali and Dink, I think it was that the point had arisen during the course of argument.
Yes.
That was the answer to it. But here, it didn't arise at all. I mean, nobody was saying to the judge, well, actually, it could have come from Carphone Warehouse, and they know it could have come from Carphone Warehouse because they actually sent them a letter before action. Did that all emerge at trial that they sent a letter before action to Carphone Warehouse? Or was that something that's emerged subsequently?
It was at trial.
Okay.
We made the. What was it, trial? They're shaking their heads.
I'm not sure that's right, my lord,
No.
but we can check.
Okay. Well, let's not take time. Right. Yeah. Sorry.
So my final point on prejudice is this. We say it is, in fact, a little rich for Phones for You to claim that they would have, for instance, canvassed this theory in cross-examination if only they'd known about it. Because when they cross-examined EE's witness, Mr Milson, who was the central witness in relation to this issue, they never put to him even the core elements of their own case that what the email showed is that he or Mr Alera had received information from Vodafone. So in those circumstances, we say it's unlikely that they would really have gone on to canvass alternative theories to discount them if they were alerted to the fact that that was something that was an issue on the table. So that's my final point on prejudice, and I have one more point to make on this.
But they must have put to your witnesses that in relation to, at least to Mrs Derbyshire, in relation to this email, that the information had come from Vodafone.
I really don't think they did. Certainly to Mr Milson, they did not put that the reason why you knew this is because you spoke to Vodafone, didn't you? That was not put. And
Just to remind me where the judge deals with this in his judgment.
sorry, 599. This is at 599 of the judgment. What page is that? That's at 427 of the bundle.
Yeah, it's paragraph 601 is what I had in mind.
Right.
I mean, whether it was evidence in chief or cross-examination, the evidence of Mr Milson was that he didn't tell Mrs Derbyshire that Vodafone were expected to leave Phones for You, and he'd no idea that they were about to pull out.
Yeah, so that was the issue that was canvassed.
So he was saying, "I'm nothing to do with me. I wasn't the source of the information."
That was rejected.
Yeah, and he rejected that.
And my point is it was never put directly to him, but he in fact got information from Vodafone.
I mean, the judge found that on balance of probability, the information came from Milson, or possibly Mr Alera.
Yes, but
At the end
not
of 602.
but not from Vodafone. That's the point. Can I? Because I know I'm conscious that I'm using up valuable court airtime. So sorry, I didn't want to toss the point out.
Sorry, it's our fault for asking too many questions.
No, not at all. But I just have one further point to make.
Yeah.
Which is on the consequences of any error if the judge took the wrong course. Because what I say is if the judge wasn't permitted to use his own view of inherent probabilities in relation to this, what he should simply have done is just put the email to one side. It should have gone into the category of documents that he referred to in paragraph 48 of his judgment, of documents that he simply was not able to infer anything useful from for the case. And in that circumstance, we'd be just back to square one, because we'd have all of the same other contemporaneous materials that supported our case, and this particular email would just be in the question.
Well, that's a sort of variant on the point that if he simply said, well, I don't know where it did come from, it didn't come from Vodafone, then we wouldn't be here either.
It is, and what Mr. Williams sought to do is to illustrate other points of evidence. If I could just illustrate one point of EE evidence that bears on this issue. It's dealt with in the judgment at 583 to 585. And this is about a workshop that took place on the 6th and 7th of May, and the notes that went with that workshop. And one sees towards the end of this section, at 585, a discussion where Mr. Milson and Alira are speculating about what they think Vodafone is going to do in the market. And it says in that quote in 585, NM, my theory is that CPW wants to secure two big accounts in the merge, O2 and EE, relations with VOD being deteriorated. Then they'll put pressure on the others. So what Mr. Milson was telling his shareholders in this meeting was that he thought that it was going to be O2 and EE going with Carphone, because he didn't think that Vodafone had a good relationship with Carphone. And apparently, he is telling this to the very shareholders who in Phones for Use case, have shared with him back in April the collusively obtained information that Vodafone is in fact going to be leaving Phones for You and going into an exclusive deal with Carphone, which is exactly what EE did. And we say this is extremely strong contemporaneous evidence that just can't be right. It would be, it's totally inconsistent, and it's at a meeting with the very same shareholders. So it would be quite extraordinary for this to be what Mr. Milson was saying if those shareholders in fact had told him the information that Phones for You claimed that they had. So my point, therefore, in relation to this email is that the judge obviously assessed it, as Mr. Williams had said, in the round, with all the evidence, and there was a very large amount of evidence in this case, and we've just sought to illustrate some examples to show that it did not support Phones for Use case. I say, even if you look at it on its face, it doesn't do that. And that, unless I can do any further assistance on this ground. Sorry.
Is that?
Yeah. Thank you. So I'm glad to say that, as I submitted to the court, the Carphone pre-action letter was disclosed and we relied on it in our closing submissions.
Sorry, say that again?
The Carphone warehouse pre-action disclosure letter was disclosed.
Yes.
And we relied on it in our closing submissions.
Right. For what?
As part of our case, that Carphone had outcompeted Phones for You. We said if you actually look at what's in here, you see that the reality, the commercial reality of this is not about collusion. It's about the fact that Carphone just basically did a lot better than Phones for You over this period, and that was what Carphone were telling Phones for You when they sent them the pre-action correspondence.
While Mr. Pickford's on his feet, can I just ask you, when you, in your opening remarks yesterday,
yeah,
said something which slightly surprised me, and I just wanted to look at the transcript. You said that notwithstanding it was rational for the operators to take the individual decisions they did, they nonetheless decided to collude. That's the case. Now I say, in addition to being commercially implausible,
Yes.
so you're saying because it was rational for them to act independently, it was commercially implausible that they would have been involved in a secret conspiracy.
Well, so that probably principally goes back to another point which I think I've just made, just above
Yes.
what your lordship is quoting to me, which is that by the time we get to the EE and Vodafone world, it really was commercially a very bad idea for either of Vodafone or EE.
So you're saying this is the case, you're not saying this at the outset. You're saying only by the time you got to the
I'm saying, but by that point it was clearly commercially implausible. I say at the outset in the pre-MNO world, I'm saying that it was far from irrational to do what we did.
But we know that after Vodafone had made a decision to exit, Mr Dunn did then seek to collude with Mr Swanty.
O2.
Sorry, O2. After O2 had decided to exit, Mr Dunn attempted to collude with Mr Swanty. That's what the judge found.
Yes.
So even the fact that they are capable and rationally capable of making independent decisions, it's not commercially implausible that they might nevertheless attempt to collude. It's called de-risking the decision.
Yeah, de-risking.
So I think I'm very grateful for.
I mean, what Mr Dunn was trying to do was get everybody to follow suit.
Yes, so I'm very grateful for your lordship picking up
because of the pricing issue on 4G. So that he was concerned. So he was doing his damnedest to get everybody to agree to collude with him. I mean, obviously, whether they did or not is obviously grounds 1 and 2. But that as to what Mr Dunn was doing, there isn't much doubt really.
Well, my submissions were too condensed here, and I apologise. What my submission is, so that the court is clear what my case actually is in 2 parts. So in relation to the first period, that is when there were 3 MNOs, I am saying that it was not. It was a rational decision to be able to leave on your own. You didn't need to collude.
But so what?
You didn't need to collude. Yes. Well. The reason I say that is because the case that we were facing initially was that it was irrational
not
to do what we did, other than via collusion. So they said you must have. They came to court and said you must have colluded because there's no way you'd ever done this if you didn't. And that was the cornerstone of their case.
And it's a logical fallacy to say because it's rational for them to act independently, it's implausible that they could collude.
Yes. So yes, in relation. So I agree with that in
Both
relation
things may be rational.
I agree with that in relation to the first
But
period.
we know they colluded in relation to 4G pricing.
There was no collusion in relation to 4G pricing that involved my clients.
I'm not saying we're talking here. You're talking here about the operator, the MNOs.
Yes. So if I could just, I'm dividing the world into 2 time periods, and I am accepting that for the first time period, it would be an overstatement to say that it was against their commercial interests to collude. My position there is that it was still perfectly rational to take an independent decision to leave Phones for You. That's for the first period. That's my case there.
That's the 2012 period.
Exactly. And so I agree with what my lord said, that insofar as one understands what I said about commercial rationality, it doesn't apply to period 1. My point is it does apply to period 2, because the situation changed but when you get to period 2, because the view of the operators was that to be viable, Phones for You needed at least 2 major players. And by the time it was just EE and Vodafone, it only had 2 major players. And so at that point, they knew that if their their rival left Phones for You, they were going to be left with a lame duck. That's the last man standing point. And so at that point, it actually became positively, commercially, a bad decision to collude. It would have been a stupid thing for them to have done. So that's the point I'm making. So it varies as between whether there are 3 M&Os or 2 M&Os, because 2 is the minimum
why
number.
would you a bad thing to collude? I mean, in one sense, they collude with each other and leave at the same time, or leave within a month of each other, or whatever.
Well,
I mean, if you don't want to be the last man standing, and you want to find out what your rivals' plans are, you try and find out what your rivals' plans are, and see if you can dovetail your plans together.
well, in my submission,
I'm not. I mean, I'm just talking in theoretically. I'm not sure I follow why it would be a bad thing to collude theoretically.
well,
Whether you did or not is another matter. But in terms of whether it was a bad thing, I'm not sure I follow that.
that's my submission. I say it would have been a very dangerous thing to do, but nothing ultimately is going to turn on that in relation to this appeal.
Well, I think we should probably have a break.
Thank you.
We've dealt with ground 3 now.
We have.
So we're moving on. Who's next in the frame? It's Dimitri. Very good. Okay. Well, should we say 11:30
Yeah, we should do it every 2 or 3 years.
It's funny thing, every 2 or 3 years it's just like one thing they do. When you do anything before the increases, everyone looks a little bit different. Good. Yeah, I mean, there is a sort of thing, but yeah.
I'll just. I don't want to go through.
Have I moved up enough?
Let me just check. Sorry, I've got it set up.
Set yourself up now.
Very much.
Which can I'm trying to move.
You're not rude.
Sorry.
No, that's not a complaint. We're just asking.
Is score ready?
I didn't mean what I said.
Court, rise and leave.
My Lord, my Lady, if I may have 30 seconds to give you one reference, and it's because my very learned junior has a much better point than I had directly before the short adjournment, which is, rationality aside, what one does see that the judge took into account is that EE had a commercial concern about Vodafone stealing a march on it and getting the volumes that it wanted. And if you go to the judgment at paragraph 603, which is on page 428 of the bundle, there is quoted Mr Harris emphasising the second bullet, as Mark Alera advised on Friday, timing is critical. Allowing Vodafone to take this volume could have disastrous consequences for EE. So EE was constantly worried, as was Vodafone, that somehow their rival was going to tie up Carphone, maybe do some exclusive deal with Carphone and leave them in the cold. Yeah. And it's in that context that they were very worried about what each other might do. But that doesn't mean that they colluded. On the contrary, if you start giving away your plans, that's very dangerous. That was fascinating.
Okay. Thank you.
May it please the court. Grounds 4 and 5 seek to challenge the judge's evaluation of the evidence, the judge's conclusions on the facts. And we're going to take the various sub-grounds in turn. The counsel whose client is most concerned with them will address each one. But I want to make some submissions on the law, the law applicable to delayed judgments in response to my learned friend Mr McLean's submissions.
Yes.
And can we start by taking up the Bank of St Petersburg case, please, which is in Authorities Bundle 5, tab 22. And if we take it, please, from page 1066. And can I just remind the court of the general approach of this court to appeals? In a sense, you don't need to be reminded of that. I know that you're very aware of it, but it's conveniently set out here in the judgment at paragraphs 30 through to 33. And you see some of the familiar language that comes up in appeals like this. So at 31, the adverb plainly, in plainly wrong, doesn't refer to the degree of confidence felt by the appellate court that it would not have reached the same conclusion. It doesn't matter with whatever degree of certainty that the appellate court considers it would have reached a different conclusion. What matters is whether the decision under appeal is one that no reasonable judge could have reached. And then we see, again, at paragraph 32, the words of Lord Justice Lewison about overruling inferences to be drawn from primary facts. And can I just ask you to remind yourselves of those principles? And then at 33, for my part, I entirely accept and endorse all these passages. They apply with particular force to a determination made by a judge after a long trial, as in the present case. The danger of island hopping is acute, and that's something I want to come back to. That said, if an appellate court is satisfied that a decision is affected by legal error, it may have no choice but to intervene unless it can be satisfied that the decision is otherwise demonstrated to be safe and reliable. Now, the appellant seeks to argue that this court should take what it has described as a radically different approach to the approach that the court normally takes, that you see set down here, summarised here, on the basis that the judgment was delayed. And you've heard my friend rely on the NatWest, the Bilter case, and some judgments leading up to that one. And my learned friend's position is that the court, instead of adopting this approach, the standard approach, should ask the following questions. First, was the judgment severely delayed? Secondly, did the judge describe incorrectly or fail to refer to or take into account any material evidence? So fail to refer to any material evidence. And thirdly, if so, is it possible that had that evidence been taken into account, it could have made a difference to the outcome? And the appellant says that if the answer to those questions is yes, then the case needs to be remitted for some form of retrial. Now, in making this submission, we say that the appellant is presenting the test as being a binary mechanistic one, and we say that that's not the case, because it's obvious, and this, my Lord, is a point that my Lord the Chancellor made, I think in response to something Mr McLean said, but it's obvious that a fact-sensitive approach is required, because there's a world of difference between a judgment which takes, say, 15 months following a 2 or 3 day trial, where the judge has evidently just put everything to one side and forgotten about it and rushed out a judgment at the end. And on the other hand, a judgment like this one, which has taken 15 months following an 11-week trial at which 41 witnesses of fact gave evidence, and where the judge has obviously carried out a painstaking review of the documents and the transcripts and compiled a careful judgment. And when we look at the cases on which my learned friend relies...
Mind you, one has to recognise that Bank of St Petersburg was a similar case, 46-day trial. I forget how long, was it 22 months in that case?
My Lord, yes, but I'm going to come back to Bank of St Petersburg because, in fact, the court did not allow the appeal on grounds of delay, and I'll come back to show you that.
I understand.
Now, when we look at the cases on which my learned friend relies, unsurprisingly, they don't require the court to apply the same mechanistic approach to every situation. And there are, in our respectful submission, 2 important features of the principles laid down in that line of cases, the Bilter line of cases, which call for a fact-sensitive assessment and which the appellant, in its submissions, has skated over. And those 2 features are this. First of all, causation. So where there has been a delay in producing a judgment, and an appellant points to a piece of material evidence that's not referred to in the judgment, the appellant will need to establish that the omission was or may have been caused by the delay. And that's an important point, simply wasn't addressed satisfactorily by my learned friend. Secondly, as the appellant accepts, the Court of Appeal will only intervene if it concludes that the piece of evidence could have led to a different result. But the critical point in our submission is that in considering that question, the court necessarily has to take a holistic view of all of the evidence and ask itself whether the judge's conclusion was against the weight of the evidence as a whole. Now, I'm going to come back to both of those points. I want to start with causation. And the causation point is important because if you think about the way that my learned friend puts the test, he says, well, here's a piece of evidence amongst the many thousand pieces of evidence that the judge has not referred to in the judgment. It's a delayed judgment if it's relevant, and if you think viewed in isolation, it could have led to a different result, ergo remittal. And we say that's not right. And of course, the starting point is that there's never any expectation that a trial judge will refer in a judgment to every piece of relevant evidence and every document that's potentially or actually even relevant that's been referred to during the course of the trial. That would be highly undesirable, as it would inevitably lead to overlong judgments containing unnecessary discussion of documents which are of marginal relevance or no relevance at all. And I don't think there's any authority for that, but there is in the bundle the Magdev case, where Mrs Justice Cockerell makes that point at paragraph 3, and for your note, it's Authorities 5, tab 23, page 1086. So it's not enough for the appellant to point to a piece of evidence that was potentially relevant that the judge omitted to mention in the judgment, and then say, well, this could have made a difference, the case should be remitted. The appellant has to establish causation, that the judge's failure to refer to it was or may have been attributable to the delay in producing the judgment. And what we're talking about there, let's make no bones about it, when you're thinking about causation, the link between delay and the omission of a reference to a piece of evidence, what the appellant's really saying is, well, the delay has caused the judge to forget it. That's why he hasn't referred to it. That's what's meant by causation in that context, failure to refer to a document. That's really the obvious causative link between failure to mention and delay. Now, the need for the appellant to establish this causative link is reiterated throughout the relevant authorities, and let me just show you two. If we turn up NatWest itself, so Authorities Bundle 6, tab 26, page 1257. And we see it clearly in paragraphs 54 to 56. Can I just ask the court to reread those paragraphs? So we see very clearly at paragraph 55 the need for a causal link between the excessive delay and the alleged errors or failings in the judgment. While we're on this case, can I just show you a different point so I don't have to come back to it? So at page 1265, 1265, paragraph 83 at the bottom of the page, under the heading the defendants structural criticism. Can I just ask you to read that paragraph to yourselves? It goes over the page.
It's the obvious point, isn't it?
And this point makes complete sense. Because
It's a point that assumes that the judge writes the judgment, as it were, chronologically and doesn't go back and check everything.
Well, my lord, I emphasise a different part of this paragraph. What this paragraph is saying, in my respectful submission, is that if the appellant is seeking to establish a causative link between a failure to mention a document and the delay, so presumably on the basis that the judge forgot about the document, if the judge has discussed the document in another part of the judgment, that's a very powerful factor that undermines the existence of the causative link. So if the judge has looked at the document and discussed it in another part of the judgment, then it's highly unlikely that the delay has caused the judge to forget about the document. Now,
You said about the causal link, but the way it seems to be put in 54 to 56 is firstly that it's a pretty easily established link because it's even possibly attributable to. And secondly, the way that Lady Justice Arden put it effectively is sort of reverses the burden because it's unless the error could not be due to delay. So it's assumed to be due to the delay unless the contrary is.
well, my lord, I think it's fair to say that there are slightly different formulations of it, but what's clear is that the causative link needs to be established. And just to fast forward to what my submission is going to be in this case, we say that in a case like this, where the judge has put together a very careful, painstaking and detailed judgment, and where the judge has not only had transcripts, but reread them and reread all of the documents in the case. At the end of the trial, and you'll see this, I don't think I need to turn it up, but in the transcript of the trial, the judge said at the very end, what I'm going to do is reread every single document referred to in your footnotes. So in those circumstances, it is, we say, vanishingly unlikely, so however the test is put, vanishingly unlikely that, that an omission of a particular piece of evidence is going to be down to the delay as opposed to the fact that the judge didn't think the evidence was important in context and could not possibly, nor would it have been desirable for him to refer to each and every piece of evidence in the judgment, because as he pointed out in his PTA judgment, that would have led to a judgment that was even longer than this one.
In a long trial of months, say 4 months, the period between the first witness and the judgment, even if it's within 3 months, say at the end of 3 months, particularly if it's 6 months, as seemed to have been accepted, would have been acceptable here, it is going to be many, many months, and that is unobjectionable. So how can one ever establish that an omission is due to the extra period from when it would not have been delay? In the references that have been made here to this being 15 months delay, well, it can't be 15 months delay because no one would have said it wouldn't have been delay if it had been 3 months. So in a sense, the delay is 12 months. But even up to when a judgment was required by, that would have been about a period of 6 months anyway.
My lord, yes, I agree, and that's why it's very important not to take a mechanistic view of this, because you're quite right to say, so I think 2 points are important. One is that it's important not to take a mechanistic view, well, there's been a 15-month delay, therefore it's likely the judge would have forgotten the document. Because as you say, my lord, following a long trial itself, even if one's within 3 months, there can be a lengthy delay between the time a document
But it's not delay. I think that's
a lengthy period of time.
I think that's important here because there's inevitably going to be many months in a long trial. And here the judge had closing submissions at the end of July.
Yes.
He could have said, I'll have closing submissions at the beginning of next term. And then it would have been
Even longer.
It would have been even longer. And so we're talking about and I think the difficulty I'm raising is how does one identify on this causation analysis whether any apparent omission is due to the period of excessive delay, if you like, the period of further delay, rather than the inherent delay in a long trial.
My lord, yes, and I think that one has to it's a fact-sensitive approach that has to be taken. And so For example, can I just posit two different scenarios that may arise? Let's say, and that's not this case, let's say that an appellant says, well, we think the judge really got the demeanour of a particular witness wrong. He forgot that that witness came across as extremely mendacious. And that's something the judge failed to say in the judgment. Well, one can quite see that if a judgment, indeed if the length of time it's taken to produce the judgment has been very, very lengthy, it may be easier to establish that the judge has failed to recollect exactly how the witness came across in court. But where one is talking here, what's being said here under ground
The
four...
difficulty with that submission, sorry,
Yes.
is that the judge's assessment of the witness is set out in his judgment.
Yes.
And counsel may think that the witness was a lying toad, but if the judge has found that he believed the witness, there's nothing you can do about it unless it's something, you know, it's very unusual indeed for this court ever to interfere with the trial judge's assessment of the veracity of the witnesses.
Yes.
We just didn't see them. Obviously, there are extreme examples. If you could show from the transcript somebody had admitted that they were lying, for example, and the judge has said, I believed him on every point, well, that would be a kind of extreme example. But that sort of assessment of witnesses doesn't really come into this, does it? I mean, what this is really about, I mean, it's what Lady Justice Harden says in Bond and Dunster, isn't it? That's why she puts it that way around, I think. If the Court of Appeal thinks that the judge has not dealt with particular bits of evidence, then unless it can be shown that it couldn't be due to delay, then the court will say, well, it looks as if that is due to delay.
My Lord, yes, but let's take that test on its face and look at the rest of what Lady Justice Arden says in that passage. So you see that at paragraph 56. So the court will order a retrial if, having regard to the diminished importance in those circumstances of the special advantage of the trial judge in the interpretation of evidence, it can't be satisfied the judge came to the right conclusion. That's the keystone of the additional standard of review and appeal against findings of fact in this situation. To go further would be likely to be unfair to the winning party. That party might have been the winning party even if the judgment had not been delayed. Now, there is a causation requirement, so whether it's put higher or lower, there's undoubtedly a causation requirement. The Privy Council reiterated that in the Pickle Properties case. And really, my submission is, in this case, the application of that causation requirement, whether one says, well, can you conclude it can't have been caused by the delay, or whether you say the burden, I'm not fussed about where the burden lies. Let's take the standard as being the one laid down by Lady Justice Arden. There's a world of difference, as I said, between a case in which a judgment has obviously been rushed out at the last moment, many months after the trial, where the judge hasn't had transcripts and hasn't reread the evidence, and a case like this, where the judge has done a very thorough, painstaking job and has reread all of the documents in the course of the case. And so that's why we say that it is vanishingly unlikely in this case that the length of time that the judge took to produce the judgment is the reason he hasn't referred to any particular document in the judgment.
Well, you say it's vanishingly unlikely, but in a sense, the same overall picture emerges in both Bank of St Petersburg and Nat Western Filter.
Well, my Lord, let me
The
take...
judge in one of the cases, I forget which one it was now, the Chancellor actually says, and Sir Geoffrey Boss says, the judge had diligently reread all the transcripts and so forth and pays tribute to that with the amount of hard work he did. But he still found the judge had not looked at everything in the round.
My Lord, can I show you Bank of St Petersburg? Because you're right to recall that. So authorities bundle 5, tab 22. If we take it from page 1075.
Yeah.
And I'm taking you to the section. If you look just above paragraph 77, you see the heading, the delay issue. Does the 22 months delay between the trial and judgment mean that the judgment is unsafe? Do you have that heading?
Yes.
And then if we go over the page, please, or rather at the bottom of this page, you see a citation from the case of Goose and Wilson Sanford. And if we go over the page,
Yes.
you see at 80, Goose was rather different from the present case, but it shows that the delay is a factor to be taken into account when the appellate court is considering the judge's findings and treatment of the evidence. Then you see Lord Scott said that if excessive delay is to be relied on in attacking a judgment, a fair case must be shown for believing that the judgment contains errors that are probably or even possibly, so again you have the causation, attributable to the delay. The appellate court must be satisfied that the judgment is not safe and that to allow it to stand would be unfair to the complainant. But it can be easily accepted that excessive delay in delivery of a judgment may require a very careful perusal of the judge's findings of fact and of his reasonings for his conclusions in order to ensure the delay has not caused injustice to the losing party. And then at 81, you have a summary of Bond and Dunster, and then you see this. That approach has no application in this case, where the judge meticulously reread all the transcripts, and I would add, in this case, and meticulously reread every single one of the documents footnoted in the parties' closing submissions. But Lady Justice Arden's judgment emphasises once again that delay by itself is not a ground for allowing an appeal. In my judgment, as I've already indicated, the delay in this case had a rather different effect from that suggested in the authorities. The judge mitigated the delay by reading the transcripts assiduously. He didn't forget or omit consideration of any material parts of the evidence. Instead, he undertook a minute, indeed commendable analysis of the evidence on each separate point. The delay may, however, I think, have meant he was less able to deal with findings he had made in the round, perhaps because the findings on one part were made at a remove from other parts of the judgment. So you can see there that, first point, the court reiterates the need for causation, and secondly, similarly to this case, the court found that these cases, the mechanistic approach my learned friend is impressing on the court, didn't apply in that case precisely because the judge had meticulously reread all the transcripts. So just two further points on causation. So the appellant says in their supplemental skeleton that we can't rely on the fact that Mr Justice Roth reread everything because that's a reason for the delay, and reasons for the delay are irrelevant. That's what they say in their supplementary skeleton, paragraphs 53 to 54. And they refer to a case in which the delay was caused by the personal difficulties faced by the judge whose family member suffered a serious illness. And the appellant says it's simply the fact of delay that engages the NatWest Bilter case law. But our point, in a sense, we don't dispute that. Our point is a different one. Our point is that when applying the NatWest case law, and in particular the causation requirement, then the reasons for the delay, or rather to put it this way, what the judge was doing during that period of time, may be highly relevant to the question of whether or not the case is a delay case, or rather whether it's a case, as the Court of Appeal found in Bank of St Petersburg, where really those cases don't apply because the judge has done such a meticulous job of rereading everything. So that's what we say about that argument. And the appellant also says, although Mr McLean didn't make this point orally, so I'm not sure to what extent it's maintained, that this court should not take account of what the judgment said, what the judge said in the permission to appeal judgment. But we say that not only is that illogical...
Well, he did touch on that in his oral submissions, but didn't press it, I think. I don't think it's pressed.
Let me just show you Dancing Ghani then. So that's in authorities, that's the same bundle, this authority is bundle 6. Tab 27. This was a case in which judgment was delivered 34 months after a 14-day trial. We see that from paragraph 3 on page 1295. But the Court of Appeal dismissed...
Sorry, what tab?
So sorry, it's tab 27. So it's page 1294.
It's in the other one. Okay. Yeah.
And it's a case in which judgment, we see from paragraph 3 on page 1295, that the trial lasted 14 days and the judgment was provided to the parties some 34 months after conclusion of the trial. The Court of Appeal dismissed the appeal. And if we look, please, if we go to page 1327, and could I just ask you, please, to read paragraph 85 to yourselves?
Yeah.
So what we see here is really the same point as I just showed you in Bank of St. Petersburg, that where a judgment is meticulous and the judge obviously reread the transcripts, it's very difficult to say that delay has caused the judge to forget some critical piece of evidence. And just while we're on this, paragraphs 86 and 87 are important because they make the point that they make an important general point that, as a general matter, the interests of justice, of course, as we've seen in the cases, require judgments to be handed down in a timely manner. But that it's not the function of this court, of course, to police that principle. The function of this court is to do justice between the parties and the circumstances of each case. So it may be a bad thing, generally, for a judgment to be handed down after a period of delay, but it doesn't follow from that the Court of Appeal should be assuming that errors have been made and remitting cases back. Now, materiality, different result. So even if the court were to conclude that the judge had forgotten about a particular piece of evidence because of the delay, the time it took him to hand down the judgment, the appellant still needs to show that had that evidence been taken into account, it could have resulted in a different outcome.
It could have resulted.
Could have resulted in a
Not
different
would
outcome.
have, but
could have resulted. I accept that. But what I want to say about that is that is that in terms of approach, the point we wish to emphasise is that the court must, in our respectful submission, bear in mind the acute danger of island hopping, what this court has described as island hopping, because there is a very real danger that particular pieces of evidence are made to seem more important than they actually are when viewed in the context of the evidence as a whole. And so it does follow, in our respectful submission, that the court needs carefully to examine the totality of the relevant evidence in order to ascertain whether the piece of evidence relied on by the appellant could indeed have resulted in a different outcome. Otherwise, one falls straight into the trap of island hopping. And listening to some of my learned friends' submissions under grounds 4 and 5, he was in effect repeating arguments that Phones for You had made at trial that were fully responded to in closing, but without reference to the competing arguments that have been made and considered, and without reference to any of the contextual and countervailing evidence that led the judge to reject those submissions. And can I just show you Bond and Dunster, which we've seen cited, but we haven't actually, I don't think, looked at. At least I haven't showed it to you. And it's in Authorities Bundle 3, tab 11. And in this case, there had been a 22-month delay from the conclusion, between the conclusion of a 10-week trial and the distribution, I think, of the draft judgment. And the critical issue at the trial was whether by around February 2003, Mr Bond Senior, sometimes referred to in the judgment as GBS, who was the claimant and appellant, had signed or otherwise agreed to be bound by a project partnership agreement for a property referred to as Admiral Court, in a claim against his son, Mr Bond Jr., so sometimes referred to as GBJ, in the judgment, and his entities, which were Dunster Properties and Dunster Holdings. And one major issue was whether Mr Bond Sr. had signed the relevant agreement, PPA, which he denied. And the judge ultimately found that he had signed the agreement by the time of a meeting on the 28th of February 2003, and we see that from paragraph 14 at page 602. But I want to show you, please, first of all, paragraphs 12 and 13 on the same page. Could I just ask you to read those? So you see at the end of paragraph 13 that that was a case in which the judge's findings were against the weight, appeared to be against the weight of the evidence. In other words, not a question of one piece of evidence militating against the conclusion. The findings were against the weight of the evidence as a whole. And if we go forward, please, in the judgment to page 620, 620 for the bundle. Paragraph 70 and following, we don't need to read them out, but you see from paragraph, what we see in those paragraphs is that, which set out the key submissions of the appellant, is that they include, we can see this from paragraph 72, an argument that the judge omitted certain evidence.
Yeah.
And then if we could skip forward to page 623, please. Paragraph 83. So we see here the court saying that the judge heard all the evidence, concluded it was possible it could have been produced as early as February 2003, clearly a judgment made with the benefit of having heard the evidence. The judge doesn't set out all the evidence relied on, but Mr Ashcroft hasn't taken us to anything which shows the judge's finding on this was against the weight of the evidence. So those words again. And then if we look at paragraph 84, I'm satisfied that the judge, so again, just emphasising that this was a case in which the judge had not referred to various pieces of evidence. In all the circumstances, I'm satisfied the judge was entitled to reach the conclusion he did on the signature issue. Mr Ashcroft has not been able to alight on any matter directly referable to signature, which was erroneous or suggestive of material misrecollection by the judge. They don't undermine, the errors don't undermine confidence in the judge's findings on other points. Again, we see the judge had full access to his notes and the documents in the case for the purpose of writing his judgment. Excluding the issue of delay and applying the normal standard of review, the appeal on this issue, in my judgment, fails. And then, could I just ask you to read 86 to yourselves?
Yep.
And then one final authority on this issue before I hand over to my friends. So authorities bundle 17, please, tab 67. This is Pickle Properties in the Privy Council. And you will see at page 4060, first of all. You'll see, I just show you this in passing at paragraph 29. There must be a basis for believing there may have been a causal link between the excessive delay and the alleged errors or failings in the judgments. That's another place where that causation issue has been underlined. But I'm just taking you to it on this second point, which is whether or not an omission could have made a difference. Now, the underlying issue in this case was whether the respondent, Plant, was entitled to a contribution from Pickle Properties as co-guarantor of loans used to purchase property. And Pickle Properties argued by way of defence, which the judge rejected, that the properties had been sold at an undervalue, so Plant had received an unjust benefit for which it had to account. And the judge concluded in the trial that the property had not been sold at an undervalue, and just for your reference, we can see that from paragraph 22, the bottom of page 4058. Now, the basis for Pickle Properties' appeal was that the judge had failed to refer to evidence at trial, oral evidence of someone called Mr Farrow, that a short marketing period, which was the basis on which Plant's expert had proceeded, would be likely to result in a significant deduction in the valuation. So that's obviously on its face a material point, and the court had just not referred to that evidence. But we see what the Privy Council makes of that, what the board made of it. If you go to 4061, paragraphs 30 to 31. So 30 sets out a summary of the argument, the submission being made about omission of reference to that evidence. And we see the evidence, part of the transcript set out over the page. And then 31, in the board's view, the fact the judge did not refer to this short excursus in Mr Farrow's oral evidence does not amount to a failure. This evidence was not a sufficient basis for the case. The judge is not to be criticised for not referring to it. So again, it doesn't follow mechanistically from the fact that a court following a delay has not referred to evidence that's relevant to an issue, that the court will send the case back for a retrial. It's important for the Court of Appeal to take a view, a realistic view, based on the evidence as a whole at trial, as to whether or not it could have made a difference. So, my lord, my lady, just one final point, and this really, I think, was prompted by the unravelling point that my lord has made now a couple of times, especially in the debate with Mr Pickford.
And the court always likes its own points, Mr Mitri.
So sorry?
The court always likes its own points.
And it's important to address them, my lord. And I don't want to go back over ground three. That's not my territory. I'd be shocked if I tried to do that. But on the cases, so on the cases on delay, the principles that you see, the underlying principle is one of interest of justice. And you saw Lady Justice Arden talk about unfairness to the respondents who have won following a trial. And so, standing back, when one is thinking about whether something which the court might think is less than ideal or an error, whether that does in fact unravel everything so as to require a retrial, it is very important in our respectful submission to stand back and ask how it could possibly serve the interests of justice. In this case, for the court to send back, for example, the issue of collusion in circumstances where, first of all, the trial judge, who looked at all of this in detail, has addressed the so-called deficiencies that my learned friends have pointed to in refusing permission to appeal, and has done that in some detail. So we know that the trial judge doesn't think those points would have made a difference. And then you ask, well, what if some of this were remitted to a different judge? What is the different judge supposed to do? Because the 41 very senior executives, well, I think 5 of the witnesses were, to be fair, on the other side, but a very substantial number of very senior executives, most of whom would not be available anymore to the respondents, can't be expected to come back to a retrial to give their evidence all over again. And so,
actually, on this hypothesis, probably giving evidence of a retrial 15 years after the event, rather than because the chances of getting a retrial on, unless it were expedited in some way before 2027, are not great.
My lord, exactly so. And so,
and it was long enough anyway. And the case had the case had quite a checkered history, didn't it? Because it was actually, I think I noticed, and which is why, I think this is why it was, there was standard disclosure under Part 31, because it was a pre, and that's, at that time, the disclosure pilot, it was a pre-disclosure pilot case.
So I think actually it's because the disclosure pilot doesn't apply to...
Because it didn't apply, yeah, okay. But so that's a false point. But it was a 2018 case, wasn't it?
It was a 2018 case, yes. And so we do very much agree with the point that my Lord has just made. Yeah. And that's why Mr Williams, in my respectful submission, point on ground 3, again, I said I wouldn't trespass, so I won't, but just allow me this. So he made the forensic point about the impact of the email being confined to August. And so the idea that all of this should be sent back to look at collusion more generally in circumstances where the judge has gone uphill and down dale and heard all of the evidence, and that a fairer outcome could happen several years, many, many years after the actual facts, and many years after the first trial, we say is for the birds, my Lord. So that's all I want to say on the general principles. I hand over now, I think, to Mr Pickford again.
Can I just say something very briefly about this interconnection point?
Yes.
I just say this. This case isn't one big jigsaw. It's a series of jigsaws. Yeah, and you'll have seen very much in relation to O2, you'll understand why I stand up now and make this point. We were out by the beginning of 2014, and the allegations against E and Vodafone...
So the latest stuff doesn't...
We're long gone.
Doesn't concern you at all.
So that's why it just makes me a bit nervous when I hear...
No, I understood. That point was fully understood.
Thank you.
Yes, Mr.
Thank you, my Lord. I'm going to try to take this at a relatively fast pace because there's quite a lot for me to cover. But obviously do slow me down.
Yeah, don't take it too fast.
Yeah. So the first issue is the green light note. It said that the judge overlooked the note which contains reference to a concern that Mr Dunn might have taken the response from Mr Swanty as a green light. So if we could please bring up that note. Best place to see it most legibly is in the supplementary bundle, volume 1, page 72. I think that might be a bad reference. Right.
No.
I've got SP2
Originals at 697.
Sorry, maybe it's at 697. Beg your pardon.
SP2
Yes, that's it.
Okay, so we've got this is the original here anyway, but it doesn't matter.
Yes.
We managed to interpret the handwriting yesterday.
Yeah.
So we've seen this, and evidently it's a highly abbreviated note of an initial call that all lawyers are typically familiar with. It doesn't record what Mr Blendis told Mr Rowe, apart from a few bullets towards the bottom, but it certainly doesn't record what he was told in relation to the risk of RD having gone back and taken the conversation as a green light. Now, what Phones for You say about this is they make two related points. They say, firstly, in terms, the judge made no reference to the note. That's what they say in paragraph 115 of their skeleton. And they go on to say that it was capable of critically influencing the judge's conclusions that Mr Swanty didn't give encouragement to Mr Dunn. Now, on his feet, I think Mr McLean slightly backtracked and said that the submission was simply that Ms Blendis would have confirmed that Swanty had been passive. But we knew that already, so that can't be a good criticism of the judge, because that's the judge's findings, that he was passive. So I understand that what they're saying is something somewhat stronger than that. And in my submission, both of those points are wrong. So firstly, the judge did make reference to this particular note. If we go to the judgment, please, in the core bundle, paragraph 176 on page 311. we see in terms a reference to Mr Blendus's note of the initial call on the 17th of October, and the judge expressly refers to the need to document our take, which is words contained in the note, the next bullet after the green light bullet. And so he was plainly very much aware of this note. He didn't overlook the note, he's referred to it. And then again in 193, the judge also refers to the same call. That's on page 316 of the bundle. So it's certainly wrong to suggest that the judge didn't take into account of the call or the note. The only complaint can be that he didn't specifically refer to the green light point. In passing, there is an important point I need to make in response to something that Mr McLean...
Well, I mean, he may not have mentioned the green light point, but he does cite, doesn't he, actually in two places in his judgment, the long email that Mr Blandus sent to Mr Swanty after he'd had the consultation with Mr Rowe.
Yes.
Which sets out the four possible four possible approaches that could be adopted.
Exactly.
And makes clear the concern of competition lawyers that there was a risk, or what they're trying to do is you know, I'm not going to use the word de-risk, but what they're trying to do is to reduce the possibility that what Mr Swanty had said or done had been misinterpreted.
Yes.
So they were yeah. I mean, all I can say is the judge doesn't actually say he warned about the green light.
No, but
as to the kind of substance of what lay behind the point, that's all there, isn't it?
It's all there, and as I told the court yesterday, Mr McLean, 4 phones for you at the trial, accepted that the note that my lord has just referred to was the best guide to what was said. That was day 32, page 92, lines 5 to 7. We don't have it, I'm afraid, in the bundle, but so that my learned friend can check what I'm saying is true.
Yeah, I mean, if you look at 177 of the judgment, which quotes the relevant bit of the email, I have said, this is Mr Blandus, I think, in broad terms, these conversations raise the prospect of collusion and anti-competitive agreements between you, which is extremely serious.
Yeah.
So I mean, you don't need to say the green light warning. I mean, that is a green light warning.
Quite. So it really would have been superfluous to have also referred to the green light point. What in order to get anything from this point, what Phones for You have to say is they have to abandon the concession that they made that this email was the best evidence and say, well, actually, the best evidence was the green light note, and therefore there must have been something that was that was known to Mr. Rowe that prompted him to say that isn't in this email. But they've already accepted that this email is the best.
So, I mean, all what Mr. Rowe's saying is that there's a danger that Mr. Dunn has gone away, thinking he's got some encouragement. Well, that's Mr. Rowe's professional opinion.
Yes.
About which he may or may not have been right, but
yes. And for phones.
But the real issue that they're focusing on is whether Mr. Swanty has done something.
Exactly.
That is capable of being anti-competitive conduct.
Yes. That's what all this goes to is what did Mr. Swanty say? That's what they rely on it for, and it is not a better guide to what Mr. Swanty said than
no suggestion Mr. Swanty that anybody actually used the word green, and either of the two people at the Landmark Hotel used the words green light.
That's
Mr. Rowe's words.
Exactly. And for their case to be true, when Mr. Rowe then goes on to comment on the draft version of that email, because what happens is Mr. Blendis sends this email that's quoted here to Mr. Rowe. Mr. Rowe looks at it, makes comments on it, and if it had really been true that in the phone conversation, Mr. Blendis had revealed something inconsistent with this email about what Mr. Swanty had done, then Mr. Rowe would obviously have picked that up. He wouldn't have reviewed this email and signed off. He'd have gone, hold on a minute, you told me X on the call, and now you're telling me Y. So we say that the whole thing is overblown. There is nothing in this point. They admit that this is the best containment evidence, and they need to be held to that.
Okay, so that's the green light.
That's green light. So the second one is said to be Mr. Blendis's evidence that the response to a letter of protest could have been to escalate and disagree with the direction of the information sharing. So you'll recall that after the landmark lunch and before Mr. Rowe's advice, Mr. Swanty and Mr. Blendis liaised over the content of an email to go to Mr. Dunn. That email was sent on the 29th of September, and it didn't contain an express objection to Mr. Dunn's approach. Now, what Mr. Blendis explained at trial was that the reason for that, and I quote, is that the response to a letter of protest could have been to escalate and disagree with the direction of that information sharing. And so what Phones for You now say to this court is that the High Court overlooked that this explanation was in fact evidence that Mr. Swanty had given more encouragement to Mr. Dunn than he admitted. That's their case, and there are 4 insurmountable hurdles with that case. The first of those is that Phones for You never put it to the judge they never put to the judge the point that they say that he failed to address. In their written closings, under the heading of how Mr. Swanty responded to Mr. Dunn, they never relied on Mr. Blendis's evidence as evidence that Mr. Swanty had encouraged Mr. Dunn. So this is a new point confected on this appeal. Rather, what they said at trial was that Mr. Swanty's response was at best passive and ambivalent. Now, where they relied upon Mr. Blendis's evidence was when they were arguing about public distancing. And you can see why, because that's where it comes in. It's the question about why EE sent the letter, the email that it did in the terms that it did, and why it didn't call Mr. Dunn out for what he'd done. And that was an issue that we lost. And that was how Phones for You put their case. And so we say, again, this is can't be raising this on appeal and claiming that the judge failed to deal with the point that he wasn't even presented with. Second point, relatedly, it was never put to Mr. Blendis that his concern that a letter of protest could have been to escalate and disagree with the direction of information sharing was in truth motivated by what he secretly knew about what Mr. Swanty had actually said. Because that's the insinuation here. That was what Mr. Blendis was saying was just a cover-up, and really it was because that fear arose from the fact that Mr. Dunn was given more encouragement by Mr. Swanty than he admitted to. But that case was never put to Mr. Blendis. So again, another reason why this can't be raised on appeal now. Third point is it's not remotely strong evidence in any event supporting Phones for You's proposition. Mr. Blendis's evidence about why he didn't send a letter of protest is simply not direct evidence for what happened at the landmark lunch. A lawyer's concern about what someone of, we might put it delicately, perhaps slightly questionable integrity might do if they were backed into a corner to try to save themselves, if EE escalated matters, is not good evidence for what happened at the lunch. It's evidence that any lawyer, any good lawyer, it's evidence of Mr. Blendis's own concerns, which were concerns that any good lawyer might have.
Well, the point comes to this: insofar as the conversation at the Landmark Hotel was recorded, the evidence was that Blendis had, I think, had made a transcript of what was recorded.
Yes.
And that Mr. Rowe had either got the transcript or listened to the recording, doesn't really matter which, but he had the substance of what was recorded. Now, if the truth was that there was something in that Mr. Swanty had said that was capable of being encouragement to Mr. Dunn, it's inconceivable that a senior partner at Slaughter and May, specialising in competition law, would not have said, for goodness sake, what you said in that meeting is really reprehensible,
yes.
And you're absolutely in trouble. And the first thing you're going to have to do is to confess and avoid to the Competition and Markets Authority.
Quite.
So it can't have been anything that was in the recording. The first bit of the conversation wasn't recorded because he only started recording it when he became concerned.
Indeed.
So whatever Mr. Blendis and Mr. Rowe knew about that bit of the conversation can only have been what they were told by Mr. Swanty, because neither of them spoke to Mr. Dunn about this. And again, neither of them can have had any concern that Mr. Swanty had said something that he shouldn't have said.
Yes.
What they were concerned about, as I read the stuff from the lawyers, is that they were concerned the whole situation where he'd gone to the meeting, there were no lawyers present, nothing was at least recorded in the first instance, was he'd left himself open to the criticism that he'd engaged in anti-competitive conduct.
Yeah, and he didn't want to escalate that, and that's perfectly reasonable. It's a difficult legal commercial decision they had to take, and that was his worry that if they did, then who knows what would happen next. Yeah. And even though they had the iPad recording, as my lord says, it wouldn't necessarily have been sufficient proof. It didn't start at the beginning. It wouldn't necessarily have answered who started it. So if Mr. Dunn went off on some frolic and said, "Oh no, that was the other guy," then it could have all got very problematic. So,
especially given that a relationship was a pretty frosty one anyway.
Exactly. I think in the light of the exchange that I have just had, it may not be necessary for me to show the court that there are other far better evidence that the court had about what went on at that lunch, and whether Mr. Swanty gave Mr. Dunn any encouragement beyond just the contemporaneous note. There are two places where it's addressed in the judgment, so I'll just do them very briefly. Mm-hmm. One is judgment paragraph 185, and that's on page 314.
Yeah. And
what that shows is when ultimately Mr. Blendis did have a protest meeting with O2's General Counsel, Mr. Smith, it was accepted. Mr. Smith said, Mr. Dunn doesn't accept he said anything that terrible, but acknowledges he asked some questions and posed some scenarios, and Olaf didn't respond.
Yeah.
So again, corroborating what Mr. Swanty said. And then later in the judgment, at paragraph 276 on page 340, we have reference to what Mr. Whiting himself said when he was giving his account of his slightly odd conversation with Mr. Dunn to Mr. Stephen Lloyd. And we see towards the end of that, Mr. Dunn, went on to say he was less sure of the intentions of EE with respect to independent distribution, because Olaf Swanty, CEO EO, was not inclined to discuss EE's distribution plan. So again, there was further good corroborative evidence that what Mr. Swanty was saying was correct. And more generally, the judge does fully canvass the decision by EE not to protest the approach. I discussed it with my lord, and just for your note, that's paragraphs 177 and also 227 to 229 of the judgment. So we said that again, there's absolutely nothing in that point. The next one is next thing that it said that the judge overlooked was Mr Swanty's acceptance that he could have been even clearer with Mr Dunn. And you'll recall we looked at some of the cross-examination in relation to this issue. Now, the court will recall that Mr Swanty was adamant and consistent that Mr Dunn could not at the landmark lunch have taken any encouragement from his response to the inappropriate approach. And Mr Swanty, in his evidence, he referred, for instance, to his body language and his tone of voice, and that was accepted evidence by the court. One sees it at, for instance, judgment 200 and judgment 222. Those are the paragraphs. So page 318.
200 and what?
So 200 and also paragraph 222.
Yeah.
Now, what Mr Swanty was unable to say is that he had expressly told Mr Dunn that the conversation was appropriate. We know that, we accept that. And when he was being cross-examined on the subject of the follow-up email on the 29th of September, that was when Mr Swanty accepted that he could have been clearer. That would have been an opportunity which he missed. So we see that cited at paragraph 162 of the judgment at 308. That's the email.
Yeah.
And then in terms of the cross-examination, that's in the supplementary bundle at page 1412. I'm afraid I don't immediately have the proper full reference. Tab 112. Tab 112. The court saw this, I think it was 2 days ago now, and if one starts on page 134,
So drop down,
at line 10, one sees that these are questions from the judge himself. But what he was saying wasn't, well, actually, well, I just asked the court please to read from line 10 on 134 through to line 17 on 135, please.
Yeah. Can we? Yeah. If we can have 135 brought down, please. Thank you. Yeah.
So what we say about this is Mr. Swanty makes a concession, which is something of a statement of the obvious, but certainly if one brings the email into account, that was an opportunity to be, in his words, even clearer with Mr. Dunn. But he also emphasises in the same passage that Mr. Dunn would not have got any comfort from him. And so there was no, we say, particular need to refer to...
But he was also making the point, I think, wasn't he, that even if they had discussed it, he wouldn't have been in a position to commit because he'd have had to go back to his own people.
Yes.
To discuss what it was that was being proposed. So I mean, even if I think he was making the point, even if his conversation had taken place, he wouldn't have given Mr Dunn encouragement that from which he could take that EE would act in a particular way.
Well, I think what he was saying was, it's A, I didn't do it. B, it's not, and B, it's not credible I'd have done it because I wasn't in a position, having suddenly had it sprung on me. I simply couldn't have given him that kind of assurance at that much. Now, there was some confusion in my respectful submission that arose in relation to this when Mr McLean was presenting this evidence, because it was suggested, and Mr McLean agreed with this idea, that Mr Swanty had got his evidence confused here because he was saying, he was indicating that he wouldn't, what he should have said is he wouldn't take on O2's, that he could have been clearer and said he wouldn't take on O2's indirect volumes. It was the, I wouldn't take on, the take on words. Does, my Lord Chancellor, do you recall that exchange with Mr McLean years ago?
Yeah.
But this is a classic illustration of the dangers of island hopping, because had you been, had the court been at the trial, what they would have heard some 5 times said by Mr Swanty before this is that he didn't think, and he said that he would not take on board what Mr Dunn was saying. He said that Mr Dunn could have had no impression from him that he would take on board what he was saying, i.e. that he was receptive to it. And he said the words take on board 5 times. And then at this point, he's saying take on, and then he trails off. And we say, it's pretty obvious, if you've made that point 5 times.
Well, I think that so your point is that what he's really trying to say is, well, I could have made it clearer to him that we just were not prepared to take this on board.
Yes, and he could have done that. He could have done that in 2 ways. He could have raised an express objection at the meeting, and he could have raised an express objection in the email. Yeah. And that's as far as it goes. But none of this undermines the point that we stand on and that we succeeded on at trial, that he gave Mr Dunn no encouragement.
He didn't actually say anything.
Because he was silent.
Okay.
So that, I think, is probably all I need to say about that. The next example, I think, is a little later on, possibly this afternoon, because I think that deals with all of the issues in relation to the lunch. Can I just take instruction from you? Yes, thank you.
Yeah, okay, thank you very much, Mr. Yes. Yeah.
So that was obviously a point that concerns O2, but I have nothing to add. I'm very happy to adopt submissions in relation to that. And I will now deal with the allegations as between Mr Dunn and Mr Lawrence. And that's Court of Appeal 4B, failure to take account, or alleged failure to take account of 2 documents. And it also comes into ground 5. It's one of the ground 5 points, which is failure to take account of evidence in the round.
Yeah.
It's necessary, as always, to begin by putting Phone's View's arguments in context. At a high level, the commercial conduct of O2 and Vodafone was entirely at odds with the alleged collusion. If you go to the judgment at paragraph 31 for bundle 18, page 267, paragraph 31. you'll see that O2 told Phones for You that it would not enter into an agreement with Phones for You for new connections on the 16th of October 2012. O2 subsequently told Phones for You that it would not be doing any sort of business with Phones for You on the 10th October 2013. I.e. by the 10th October 2013, O2 had said to Phones for You, we're completely out, we're not doing any more business with you. I have to flick between the judgment paragraphs a bit. If we go to page 344, please. And it's the final sentence of paragraph 292. You'll see that in November 2013, so a month after O2 had said to Phones for You, we're out, what Vodafone actually did was sign an overlay agreement with Phones for You under which it agreed to sell increased volumes of connections through Phones for You. So completely the opposite of the alleged collusion. And if we go back to page 267, paragraph 32, the point I referred to when I was talking about jigsaws earlier, Vodafone didn't give notice to Phones for You until 7th of August 2014. So long after O2 had completely exited Phones for You. So the obvious point is that that absolutely basic course of conduct is simply not consistent with the allegation that there was a concerted practice between Mr Dunn and Mr Lawrence. And I think, again, just last short bit of context is it's important to know that at trial this allegation was very much secondary to the Dunn-Swanty allegation, to the landmark lunch allegation. And that's no doubt why you see it dealt with relatively shortly in the judgment at paragraphs 236 to 245. That's simply because this wasn't one of the major focuses of Phones for You at the trial. So let me deal with ground 4B, that's the failure to refer to two documents in the judgment. And our submission in relation to both of those is we're in the real realms of periphery. This is stuff of secondary importance in relation to these issues. First of all, there's something called, it's a slide presentation by Mr Maple. So it was a slide presentation prepared by Mr Phil Maple, who was the head of commercial sales and service at O2, and it was prepared for presentation at O2's off-site meeting on the 12th to the 13th of September 2012. I'll come back to that because the date is significant given the allegation being made. And if we could go to the core supplementary bundle, tab 13. And you were shown this by Mr McLean in opening.
Yeah.
So you'll see the date on it. Distribution Game Changers, September 2012, Phil Maple. So produced by Phil Maple for the meeting on the 12th and 13th of September. And the single slide from the deck that the Phones for You seeks to rely upon is over the page. So CSB, page 55.
It's 0.5, isn't it, if you drop down?
Well, I'm going, before we come to that,
Yeah.
this is a slide that seeks to predict what might happen. And it contains a number of assumptions, not just the one in 0.5. So if you look at the box at the top right with the heading Assumptions, you'll see a number of assumptions are being made for the purposes of this wargaming, if I can call it that. If TFEU withdrew from an indirect, another MNO would follow. So that's not just Vodafone, that's saying, well, if TEF withdraws, another indirect might follow. If another MNO, not specified to be Vodafone, if another MNO follows P4U exit, remaining assets could be purchased less than current MV. And then EE launch LTE, which is another way of referring to 4G, direct only, other MNOs follow suit. So the whole premise of this slide is a number of assumptions that are being made. And indeed, that's the whole purpose of these sorts of wargaming slides. We saw them again and again during the course of the trial. The whole purpose of these wargaming slides is to proceed on the basis of assumptions. And of course, that's inherent in the very exercise of trying to predict what might happen in the future in order to make commercial decisions. It's an inherent part of this exercise. Now, this slide that's relied upon by Phones for You was one of 31 slides in this slide deck. And no other slide refers to an assumption that Vodafone would follow suit. This is the only one. The slide deck, albeit not this particular slide, is addressed at paragraphs 128 to 132 of the judgment. If we go to Court Bundle, tab 18, page 298, and what the judge does is he explains that Mr. Maple prepared this slide pack to support his suggestion that O2 should sign a new one-year deal with Phones for You for new connections. That's what Mr. Maple was putting forward at the meeting. But Mr. Maple's proposal was rejected at the meeting. And you see that in paragraphs 128, 129 and 132. So Mr. Maple makes an assumption about Vodafone in order to support a proposal that is rejected at the meeting. The suggestion that this is evidence that O2 knew what Voda would do and was acting on that basis just isn't made out by the facts. And it's important to understand that there were many similar slide presentations, these game changer presentations as they're called, that were produced as part of the O2 decision-making process to leave Phones for You. None of the other sets of slide decks contained an assumption that Vodafone would follow suit. Again, if this really were the fruits of consultation between Mr. Lawrence and Mr. Dunn, O2 would have been basing its commercial decision-making far more clearly on that. It simply wasn't part of the process, part of the decision-making.
Good. Sorry, can we just have the slide back on?
Sure. So that's CSB tab 13.
Although the slide deck is prepared with a view to trying to persuade people to agree to renew the contract, that's not this scenario that's being considered here, is it?
The specific one in 5. Yeah. No, I accept that. The background was this was being produced for a particular proposal, which was to stay in Phones for You for another year. And this was part of the considerations that Mr. Maple was putting forward. I think there was 30 odd slides in this deck.
But the point against you is, why does it specifically mention Vodafone?
Because Mr. Maple chose to put forward that assumption. It doesn't expressly refer to Vodafone in the assumptions at the top of the page, in the box at the top of the page, for example. And the assumption in relation to Vodafone features nowhere else in this slide deck or in any other slide deck. If this was really O2 knew what Vodafone was going to do, there would be some other evidence.
Well, there's another way of looking at it as well, it seems to be, possibly, I don't know. And you'll tell me if this is wrong. But this is in September 2012, so it's all forward-looking. And at this stage, 4G, EE were going to launch 4G, probably in 2013, but certainly either in the fourth quarter of 2012 or 2013. And one of the assumptions is that they're only going to launch it direct. Mm-hmm. So they were not going to use Phones for You and CPW at all for 4G, but they're basically going to cut them out of the picture, as it were.
That's one of the assumptions.
So that when you get to business impact, paragraph 5, one of the reasons for the assumption that Vodafone follows suit is it's all on the hypothesis that EE have already done it. So Vodafone, apart from O2 themselves, the only people left in the game of Vodafone. So it's just an assumption which is based on the logic of his own previous assumptions. It's not based on any market information or collusive information or anything of that kind.
That's certainly one of the possibilities. To be absolutely fair to Phones for You, that's not the explanation Mr. Maple gave. But
no, I'm just looking at the
absolutely, I
document.
see the logic, and that could be one of the reasons.
Yeah. Okay.
But there's another further problem with.
What's BBE?
Sorry,
as a matter of interest.
Where am I looking?
Carphone in the boxes in 2013. CPW BBE.
I'm not sure. It's not something.
I think it refers to a change of control at BB. Was BB the company who?
I don't think it didn't come up at trial.
No,
it's not even a failure of my memory. I think it's just.
Then whoever the owners of Carphone Warehouse were at the time, possibly.
There's another further problem with this, is that beyond the sort of contextual points that I've just made, which is that the argument that Phones for You is now seeking to rely on, based on this slide, is contrary to its pleaded case, and therefore it's quite simply inadmissible. Phones for You's distinct allegations about collusion between Mr. Dunn and Mr. Lawrence were made in February 22. That was shortly before the start of the trial in May 2022. And they were made with the benefit of disclosure and witness statements. So these came very close to the start of the trial. That's in the judgment, CB 18, page 331, para 242.
Yeah.
You'll see the judge explains this in the context of Mr. Lawrence not giving evidence. So the point is, these specific allegations about Dunn Lawrence come very close to trial after disclosure and witness statements. The pleading is in the re-amended particulars of claim at paragraph 50S. So that's core bundle tab 21, page 512.
50S.
50S. S for sugar. And if I could ask you to read that, please. And obviously the amendments made just before trial are in the green font. They are the re-amendments.
It's the green ones that were made just before trial.
That's right. So you'll see that the allegation being made is that on or around the date of 19 September 2012, which was the date of the landmark lunch, Mr. Dunn approached Mr. Lawrence and made similar comments and or proposals to those he made to Mr. Swanty. And then it said, it is to be inferred that these meetings or calls were made after O2's off-site XCOM meeting, at which O2 had taken the provisional decision to exit Phones for You. So you'll see it is to be inferred that these meetings, including the Dunn-Lawrence meeting, were pursuant to the decision which had been taken at the 13 September 2012 meeting. So the allegation is that Dunn and Lawrence colluded.
Is it 13th of September meeting? Is that a mistake for the 19th of September?
No, that's a reference to the O2's off-site meeting on the 12th and 13th of September.
That's a reference to the slide deck, is it?
Yes, because it's referred that these meetings, i.e. the Landmark Hotel and the Dunn-Lawrence meeting, were pursuant to the decision O2 had taken at the 13th September meeting. And as I've shown you, the slide upon which Phones for You seeks to rely for this purpose was prepared before the off-site meeting. So by definition, the slide cannot be evidence of an anti-competitive approach after the meeting had taken place. And our submission is it's not open to phones for you to seek a remittal to determine an allegation that does not form part of their pleaded case.
Is that a convenient moment, Mr. Hoskins?
Can I make just one short point,
Yeah, sure.
which is, even if Phones for You had pleaded that there was collusion between Mr Dunn and Mr Lawrence prior to the 12th or 13th of September 2012, there was no evidence that Mr Dunn and Mr Lawrence had any contact prior to that date. So there's evidence that they met on the 10th of October 2012. There's evidence that Mr Dunn called Mr Lawrence in November 2012, but no evidence of any contact before that date. And that may be, and I can only guess, that's why Phones for You didn't plead a case based on collusion prior to the 19th of September or the 13th of September. And that is a convenient moment.
Just so as I think we indicated, we've got to rise at 4:15. And I think quite a few know the reason why we had to rise then is because we've got Mr Justice Roth's valedictory tonight at 4:45, which we obviously will, I think all of us will be at, and there's a reception afterwards. And I just wanted to be sure that everybody was aware of that. I know quite a few of the council will be there. I know Mr Dimitri, I think, is speaking. But I just wanted to be sure that your respective solicitors and clients were aware of it. And we will obviously, I mean, those of us who go to the reception, I may not be able to myself, but we've discussed it. We will not discuss the case with any of the council in the case. We will not discuss the case with Peter Roth. You probably wouldn't want to discuss it anyway. Try to. Just so that there's no concern, I thought it was probably sensible. I probably should have mentioned at the outset. It only really, it was only when I was thinking about it this morning. I thought I'd better mention it in court. But if there is any concern at all, come back at 2 o'clock and tell us. Okay? Well, otherwise, we'll see you at 2 o'clock. Thank you.
I mean, I massively, I've tried, I crawled back a little bit of time. Actually, my first one, really like to say that. I've cut down everything else. So I'd like to be very short.